Good morning. The Senate Committee on State Affairs will come to order. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Here. Good morning, and we'll begin with our posted business. The chair lays out Senate Bill 447 and recognizes its author, our dear colleague, Senator Hinojosa, to explain the measure. Good morning.
Thank you, Mr. Chairman, and thank you, members. So early in the morning, my body clock is a little bit behind, but this is a simple bill where the City of Mission is asking for the election that's right now in the present law is set for May to be moved to November. And there was a proposition on the ballot where the citizens of Mission voted by a vast majority to change the date of the election from May to November. And the City Council also passed a resolution in support of this change, and that's what the bill does. I have here Mayor Nori Garza from Mission in the event that any testimony is needed on this bill.
Thank you, Senator. Members, any questions for Senator Hinojosa? And you said the voters were asked about this, and the voters approved a referendum. That's interesting. I'd never heard of that. That's really strong support.
It was on the ballot, and they all said yay by a large two-thirds majority.
Thank you, Senator. We'll hear from the mayor then. Thank you very much.
And the mayor is here to testify if needed, and I would ask that we place on the local calendar.
Thank you, Senator. We'll open testimony on Senate Bill 447, and the chair calls Honorable Nori Gonzalez Garza. Mayor, welcome.
Good morning. Thank you.
Good morning. Get comfortable there and introduce yourself. Give us your testimony.
Okay, well, thank you very much.
And get closer to the microphone so we can
Okay.
hear you.
Thank you very much, Chair and committee members. My name is Nori Gonzalez Garza, and I am the mayor of the City of Mission. And I'm here to testify in favor of the change of our election from May to November. Last May, we did have an election, charter amendment, and we had this as an item, and it overwhelmingly did well. We got a 78% in favor of changing the election from May to November. So we're excited about getting that done. We feel that it'll have a better voter turnout, as we saw last November. So that's one of the reasons actually that's the key reason to get this done. The other is a financial thing. We feel that it'll be less expensive if the entities that are involved in the election share the cost, and so therefore will benefit us in that way too. So it's a twofold win for the City of Mission.
Thank you, Mayor.
Thank you.
Senators, any questions for Mayor Garza?
Any questions? Yes.
Thank you for being here. Your senator has already worked this, and
Yes.
we're going to anticipate the bill's going to be moving pretty quickly. Thank you for bringing this to us and taking care of everything back home.
Thank you all for doing what you're doing for the state of Texas and all the residents all across the state. And a special thanks to Senator Hinojosa for initiating this bill. Thank you.
Thank you, Mayor. Good to have you.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 447? Anyone else on Senate Bill 447? Seeing none, hearing none, public testimony is closed, and the bill's left pending at this time. Senator Hinojosa.
Thank you, Mr. Chairman, and thank you, members.
Thank you, Senator, and I'm sure this will be moving pretty quickly the next time we have votes. Thank you very much. The chair lays out as a matter of pending business Senate Bill 17. And Senator Hall sends up a committee substitute, Senate Bill 17, and the chair recognizes our dear colleague, Senator Colcourse, to explain the substitute.
Thank you, Mr. Chairman and members, and good Monday morning to each of you. I want to say thank you also, Mr. Chairman, for the layout last Thursday and being able to take input not only from members but listening to public testimony. And as we know, the process is extremely important to do that, to get feedback. Members, if you weren't here on Thursday, I talked about since last session in Senate Bill 147, I had talked to staff and said this is our #1 issue to get right, to make sure that it is drafted in a way that is constitutional. As we've seen, many states have acted since we have not. There were news stories even over the weekend about the concern with our adversary nations and what they potentially have been doing with farmland and other things. So let's talk about the substitute that is before you right now. The substitute adds to real property covered by the bill groundwater and water rights. Senator Middleton brought that up during our hearing. It had also been mentioned to me if we're going to protect our minerals, our oil and gas, our timber, why not something so precious as water? I just came from Water, Agriculture, and Rural Affairs, where we have before us SCR 13, talking about the amount of water that Mexico is not giving to us. So certainly we should protect that as well in this bill. The second change would be throughout the bill, the concept of title is eliminated because real property in the bill would have ownership that isn't subject to title, for example, water. So we cleaned that up. The bill adds another class of prohibited individuals as those working directly or indirectly for an adversarial government. That is, they work directly for the government or they're a contractor. That would be on page 5, lines 8 and 9. We heard from folks and people who testified at the hearing and other advocates that the police power language that references public health and nuance is confusing. And in consultation with the governor's legal counsel, it was deemed unnecessary, so we have removed that. So references no longer appear in section 5.254, that would be page 4, line 20. The fifth change would be the divestment legal action is changed to an in rem proceeding. And I mentioned that in my layout, an in rem proceeding versus what we currently have. And that means the legal case is against the real property and not an individual. As I mentioned to you, we've had some great legal minds working on this bill. That was a suggestion that we have incorporated from legal counsel to better tailor the bill as a legal action to ensure control of land and natural resources. So that would be page 5, line 10. And then finally, based on input from those in the real estate community, we made the senior lien holder receive payment in order of priority after the proceeds. We also provided that proceeds can cover the cost of a successful divestment proceeding. This addresses some concern that it is merely the cost of doing business for a prohibited entity to acquire real property. So I do want to say that I had someone stop me in the hallway on Friday in the real estate community, and they thanked my staff, and thank you, Grant McLaughlin, and some other great staffers that have been working on this for the input and the time that we have taken to, again, get this right, workable, and constitutional. That was the #1 thing that I really thought was very important, is that, you know, certainly it will be challenged. All of them will be challenged across our nation. But I believe that this puts Texas at the forefront, where we are not currently. I can assure you, we are not we are probably the state with the least protections at this point.
Thank you, Senator Colhorst. Senators, any questions for the author about the committee substitute on Senate Bill 17? Very well. Thank you for explaining that. And as we move forward in the process, the substitute haven't been explained to us. We'll be ready to move on that when it's time to move the bill. Thank you very much for being here and for all your work on this bill, continued work on the bill. Thank you.
Thank you, Mr. Chairman. I think it's a very important bill, and, you know, I look to the federal government also finally awakening, and it seemingly is becoming a bipartisan issue to understand that we are under a real threat with our most precious assets, which is our land and natural resources. Thank you.
Thank you, Senator. Thanks for coming back. And Senate Bill 17 will be left pending at this time for action very quickly, I'm confident. The chair lays out as a matter of pending business, Senate Bill 3. Senate Bill 3, of course, the bill that we heard And there is a committee substitute, which has already been explained to us. Senator Perry moves that we adopt the committee substitute, Senate Bill 3. Is there any objection to adoption of the substitute? Hearing none, the committee substitute is adopted. Senator Perry moves that we report that Senate Bill 3 as substituted to the full Senate favorably with the recommendation that it do pass and be printed. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffirini, Paxton, Hughes.
Aye. There being 6 ayes and no nays, the committee substitute Senate Bill 3 will be reported favorably to the full Senate. That one probably ought to go to the floor, or okay, all right. Very good. Thank you, Senator. Returning to our agenda, the chair lays out Senate Bill 893. 893 recognizes our colleague Senator Johnson to explain the measure. Good morning, Senator. Welcome.
Good morning, Mr. Chairman and members. This committee deals with many very difficult issues. This is not one of them. This is a bill that passed out of the Senate last session. This is simply a statement that we all made, and I hope we'll make again here today, that we do not want people to use technology to create images or videos that are intended to deceive the public, to alter the outcomes in elections by making people believe things about a person that are not true. The committee substitute, it defines deepfake images and videos. It is a rising problem. We need to continue trying to put things in place that will allow us to stop that. There's a committee substitute that will be laid before you. The differences in the committee substitute is we're just honing a little bit the definition of what we're talking about here when we're defining a deepfake video. The previous draft of the bill said that a deepfake video means something where you appear to depict a real person performing an action that did not occur in real life. I wanted to hone that a little bit because the action might have occurred in real life, just done by someone else. So the committee substitute says the deepfake video is something that appears to depict a real person performing an action that that person did not perform. Other differences from last year is previously it was limited to within 90 days of an election. We no longer think that 90 days of an election is long enough. You make a deepfake video or an image anytime with the intent to deceive the public, you're guilty of the crime set forth here in this bill. Thank you, members. I'm here for questions, and we also have witnesses.
Thank you, Senator. And so Senator Perry sends up the committee substitute, which the author has explained to us, the difference between the originally filed and the substitute. And thank you. Senators, any questions for the author at this point? Senator Hall, you're recognized.
Thank you, Mr. Chairman. I understand the full intent of your bill, and I support that. I mean, question I have is, we're always concerned about the unintended consequences. What would this do, let's say, for a cartoon characterization of someone?
Excellent question, Senator Hall. And the bill addresses that explicitly, and those kinds of things are excluded. If you want to put a picture of somebody and make them look like a goat, that's fine. We know you're just being, we have a long history in this country of satire, and that can continue without any threat from this bill. It's only when you're really trying to deceive people into believing something that's not true. So it's something where you might change the way someone looks, but they look real, right? Satire is protected expressly in the bill.
Okay, and I understand that. I mean, satire has always been, it's probably one of the first forms of communication we had out there, and it's been great when it's properly used. My just concern is now using it to say, you know, you depict someone looking like a goat or a donkey, that you were trying to portray them as something they aren't. I mean, I'm concerned about the unintended consequences, and I want to make sure that the true satire does not get affected.
I think that's a valid concern, and Senator Hall, I'll direct you to page 2, beginning at line 8, section E of the bill. Says that this term, altered image, does not include a cartoon, a caricature, or any other image that a reasonable viewer would understand to be a satirical representation of the individual, or an image altered only to change the saturation, brightness, contrast, color, or any other superficial quality of the image. It's got, we think law enforcement and the courts are going to have sufficient ability to distinguish between when people have really a bad intent that we're trying to prescribe and when they're not.
Okay. And I really asked the question to make sure that it's clear of the intent of the bill.
The intent
And
is
therefore,
clear,
anybody
and
that
it
might
is
be
clearer
wanting
now.
to pervert it.
It's clearer now as a result of this discussion.
Thank you, Senator.
Thanks, Senator Hall. Members, any other questions for our dear colleague, Senator Johnson? Senator, let me ask one, and thank you for your work on this bill. This is a problem, and AI presents such daunting challenges as they tell us that we may be reaching the point where an AI video is indistinguishable from the real thing. So all the more reason, I am curious about the time limit. This is just a question for discussion. I'm not. This is a great bill. I can almost quote this, but you'll remember this quote from Justice Brandeis in Whitney versus California. He says, "If there be time to expose through discussion the falsehood and fallacies, to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence." Again, that's a big if there's time, if there's an opportunity to sort it out, to get out the truth. Should there be some temporal relationship to the election, or is this, again, this is almost philosophical, but you're a very smart guy, and I know we're all free speech people here, and we're not for misleading people or for lying, but is there, since we are limiting speech, should there be some time frame in relationship to the election, or is just any time okay? Help me with that.
Yeah, Mr. Chairman, I think that also is just an excellent point. We very often try to set timelines in statute, and sometimes it's helpful, like when a deadline to file this or we're not going to deal with you, right? Deadlines are helpful. But when we try to arbitrarily pick a point in time and say, that's the moment when we get serious, it's troubling. But where I think we take care of that in the statute, and again, it's a very serious consideration, because if you do a deep fake this year and 47 years from now, somebody says, oh, that was bad intent. The bill specifically says, with the intent to deceive, and I failed to read this earlier in my layout, intent to deceive and alter the outcome of an election. Now, that judgment in time is going to fall to human beings on a court who are going to say that, you couldn't reasonably have been said to be trying to alter the 2032 election with a video that you made in 2021. But you might well have been seeking to alter the outcome of the 2032 election if you made it in 2030, maybe even 2029, and I don't know, and that's going to be the facts that are determined at trial. We will be able to look at this person's intent and make the call, and I think that's probably better than trying to put a line in time, because the line in time is manipulable.
Thank you very much. I wanted to see what you thought about that.
I think it's
I've
an
been thinking about it
important
since we saw the bill. No, thank you very much. Senator Perry, you're recognized.
I can. I can.
Just reading through the bill, and I probably missed it, and maybe it's attached to the actual offense of Class A misdemeanor or B or whatever. Who is going to be your referral for? So if I look at the internet and clearly somebody's done something that's not what I did, do I report that to the AG? Do I report that to a DA? Do I report that to who's going to be responsible for follow-up, I guess, on this particular issue?
It's a state law, and I believe we're going to have some testimony here from DPS that I think might address that better than I possibly could.
Sure. Well, I just want to make sure, because sometimes we do things and say we did things, but at the end of the day, we didn't really provide a path for enforcement. And I think it's important that that's clear when we leave here this session, that who's enforcing it. The other side of that is, and it's not, obviously we're state, not federal, but if it's on the internet, is that a federal crime at that point?
It may be in addition, but it will also be a state crime, and these will be prosecuted and reported in the same fashion of any other election code violation.
Is there any opportunity to make the social media network, to say if it's Facebook, any of those guys responsible for cleaning up if those people are found to be a habitual problem, can they remove them down the road? I mean, it's not part of your bill, but down the road, is that something where the state could force, if this guy's a known felon in this regard, or criminal in this regard, or misdemeanor, whatever, can they be asked to kind of police their own so that we're not using state resources?
I think that's a highly worthy inquiry.
Okay, thank you.
Any other questions for the author? Thanks, Senator Johnson. We'll look forward to the witnesses. Thank you for your layout explanation.
Thank you, members.
We'll open public testimony on Senate Bill 893, and we do have as a resource David Dixon from the Texas Department of Public Safety. Senator Perry, would you like to ask about that enforcement question with DPS? Please come ahead. And while Mr. Dixon's taking his seat, the chair calls Denise Siebert, Grayson Gee, Renzo Soto, Adrian Shelley. So we're looking for Denise Siebert, Grayson Gee, Renzo Soto, Adrian Shelley. And we'll start with DPS. If you don't mind, introduce yourself and tell us who you represent, and Senator Perry has a question for you. And welcome.
Good morning. I'm David Dixon. I'm with the Texas Department of Public Safety. I'm a major with our Criminal Investigation Division, and I actually supervise our Computer Information Technology and Electronic Crimes Unit.
Major, thank you for being here. Senator Perry.
Yeah, so you heard my last question is, how do we enforce this? Who refers, where do they refer to? What's that look like? Would it ultimately involve a federal referral because it's over the internet? I mean, can you give me, or give the members kind of an outline of how we get there? Because I don't want to pass a bill, say we did something, and then find out later that there's no teeth in it because of lack of enforcement. And then I'll follow up, secondly, this is going to require resources, and do you have resources to follow up on this? Because it's going to open up a fairly broad Pandora's box, if you will, because everybody could argue that I've been wrong today because that wasn't me. So give me kind of a perspective, but first of all, is it you guys that would be responsible for enforcement, and how would those referrals come through?
I think for y'all, it would be either your local agencies that, for whatever county jurisdiction y'all are, or us. Both of us would work together. If you refer to us, you come to us, DPS, we're going to reach out to the local county or wherever you're from to make sure they're not already working something like that. And then we would follow up accordingly.
So the DA, so if in Lubbock, Texas, something came up, I would go to my DA, and it would be up to the DA whether they would investigate it or not.
Or the sheriff's office or the PD.
Okay.
Or you could go to us. We're here, that's what we're here for, to help you, sir.
All right. How about resource? I mean, I don't know how much of this is going on. I suspect a lot. You can't hardly believe anything you see anymore. Is this going to overwhelm you guys? Potentially? Hard to speculate, but you know what's in the social media environment, right?
Yes, sir.
Okay. This one. So everybody heard the question. I'll repeat it. First of all, question was, where does referrals go? Your response was local DAs or state DPS. Secondly, if it would have been a federal referral, I suspect because it is using the internet, and you believe it would be, is basically what I'm picking up.
Yes, sir.
And then thirdly, is this going to overwhelm you guys potentially, because I would say it's better that a majority of what's on Facebook now doesn't represent truth. That's what I do. I'm not sophisticated enough to go to all those other formats, but a lot of that stuff's floating around, so you can't speculate what the volume is going to be, but knowing what's out there, do you have any concerns that this could really become a real internal burden to chase these deals?
No, sir. So what we would need is software to say that, yes, it is a deep fake video so that the DA's office could move forward with it. And then we'd have to work with the social media company that posted, like Facebook, to get the IP address to locate the individual. But as far as overwhelming us, so the original law passed in 2019, and I can tell you, from my experience, we haven't worked any of these, so.
Good, good. Well, that's good to know. I guess you make a question, you gave an answer that, a question. So these are typically technology related that you can prove whether one's been a fake or not? There's some marker or some way to identify if you have the software, or at least highlight the potential through software?
So when they post it, we would have an IP address from where it's posted. That would help us. Hopefully it's in the United States, and hopefully it's in Texas, so that we can move forward with it, sir.
Is your relationship with the social media platforms in a way where they respond accordingly and helpful?
Yes, sir. We work with them currently a lot.
That's changed. So I appreciate the law, and I think it is timely, and I think we need to do it. I think as we mature in this technology conversations, it's incumbent upon you guys to be clear on how do we do our job the best and more efficiently. And if it's software technologies and things to get that done, and then whatever we would do to encourage the platforms, which has not happened very much or very easily with respect to child pornography and some of that. You get a little more cooperation with them, but it's been a real battle. So thank you. Good job.
Mr. Chairman, if I might.
Senator
ask
Johnson,
this
go
witness
ahead.
a question. Senator Perry was bringing up enforcement. Mr. Dixon, Officer Dixon, you testified that it's a piece of software. Is this a prohibitively expensive piece of software?
So we looked 2 years ago. We got estimates, and it was about $8,000 per license that we would need. So again, I would start out if, seeing as we have not dealt with one yet, I would start out with only getting 2 or 3 licenses to move forward, and then as it progressed. As far as software, that's actually pretty cheap nowadays.
So it's essentially no fiscal note from our perspective.
Yes, sir.
Okay, and Major Dixon, also, could this software be used to detect other crimes as well?
When we looked specifically for deepfake technology to be able to say that it is deepfake so that we could go to a DA's office with it. To answer your question, I don't know. I don't believe so. A lot of these softwares are very specific.
Let me ask a better question. It could be used to detect other crimes using deepfake video.
Yes, sir.
For example, child pornography.
Yes, sir. Yes, sir.
Thank you.
Is there any other questions for Major Dixon at this point? Senator Hinojosa, you're recognized.
Thank you, Mr. Chairman. Just a quick follow-up regarding the IP addresses and all that. I mean, does the software allow you to break through the firewalls and, those programs that, change your IP or make you seem like you're, on the other side of the world?
Yes, sir. So I'm sorry, let me make sure. You're asking if we can get through that software?
Yes, sir. That's a relatively inexpensive software we can put on any of our computers for a minimal amount of money per month and make it look like we're logging in from somewhere on the other side of the world.
All we have is
And Major, of course, as you know, if we ask you something that would the answer would be helpful to people trying to evade the law, you can always tell us that. So I know you know that, but be aware of that, please. Go ahead.
when we're originally going off that IP address, it's going to give us the location for that IP address. Now, if they've changed it through VPNs and stuff, it's going to be hard to get. To answer your question, it would be hard, sir.
Okay. Thank you. That was just a question. Thank you.
Thanks, Major. Will you stick around for this panel in case we have more questions?
Yes, sir.
Thank you so much. And we'll continue over here to my left, your right. Introduce yourself and give us your testimony. Get close to that microphone.
Yes, sir. Well, thank you, Chairman Hughes and Vice Chair Paxton and members of this committee for the opportunity to testify today. My name is Grayson Gee, and I serve as a technology policy analyst at the Texas Public Policy Foundation. And I'm here today to express support for Senate Bill 893, which addresses the growing concern of digitally manipulated media in our electoral process. Free and fair elections are the cornerstone of our constitutional republic, providing citizens their most fundamental means of self-governance and ensuring the legitimacy of our democratic institutions. Any threat to the integrity of these elections is a threat to the republic itself. As technology advances, so does the sophistication of tools that can create convincing but false images and videos of candidates and elected officials. This legislation strikes a necessary balance between protecting electoral integrity and preserving free expression. By criminalizing deepfake videos and altered images created with deceptive intent, SB 893 provides guardrails against some of the most harmful forms of digital misinformation. I particularly commend the bill's careful drafting in several areas. First, the bill maintains proper intent. Prosecution requires both intent to deceive and intent to injure a candidate or influence an election result. This ensures that the law targets genuine electoral interference rather than protected speech. Secondly, the bill's explicit exemptions for satire, caricatures, and superficial image adjustments protect legitimate forms of political commentary and artistic expression. As we approach an era where artificial intelligence makes creating convincing false media increasingly accessible, this legislation represents a measured approach to preserving election integrity without unduly restricting free expression. The Texas Public Policy Foundation believes SB 893 appropriately addresses a growing threat to our electoral process while respecting constitutional boundaries. I appreciate your consideration and would be happy to answer any questions. Thank you.
Thank you for your testimony, and we're going to hear from each witness, and then we'll have questions. Thanks for being here. Welcome. Introduce yourself and give us your testimony.
Thank you, Chairman Hughes, members of the committee, Senator Johnson. My name is Renzo Soto. I'm Executive Director for Texas and the South at TechNet. We are officially neutral on the bill today, but we do want to thank Senator Johnson as well as this committee for taking up this important issue. We absolutely agree with the intent of it, what it's looking to do. We've approached the author's office with some belt and suspenders types of amendments to strengthen the bill, and we look forward to working on those outside of committee. Thank you very much.
And thanks for your testimony. Welcome. Introduce yourself and go ahead.
My name is Denise Seibert. I represent myself. I'm supporting SB 893. Thank you, Senator Johnson, for this bill. Thank you, senators, for hearing me. A person committing an offense to deceive with intent to injure a candidate or influence the result of an election is a crime and should be punished by law. Creating or causing to be created deepfake video can influence an election. The harm caused by false information can affect the candidates running for office. My friend Molly White ran for state representative for District 55 position. I spent many hours volunteering for her campaign, so I understand the time, the cost, and the commitment it takes to run for office. And so do you. I was with her from the beginning to the election results. The harm caused by false information we've all seen with this technology and the false information that it can be released. The ease of manipulating information can lose an election and slanders the candidate's reputation and sometimes for life. This can be quite a task to prove, but if the fines and penalties are large enough and strong enough, it will discourage any release of false information. Make sure that you can enforce these policies. False information and videos can cause anyone running for office to lose their election and their reputation. It's no longer about the freedom of speech when a false, slanderous video is created to deceive the public about a candidate. I support SB 893, creating a criminal offense for false images, videos, and sources. Thank you again for hearing me.
Thank you, Ms. Siebert. Welcome. Introduce yourself and go ahead.
Have a testimony?
Oh, yes, please. We'll get that from you. Thank you.
Okay.
Gentleman over here will take it from you.
Thank you, Mr. Chairman. Members, Adrian Shelley with Public Citizen here speaking in support of Senate Bill 893. As mentioned, this is a straightforward bill. We're already ahead of the curve here. We've had a deepfake video law in place since 2019. Thanks to you, Mr. Chairman. Thanks for that. We are just adding still images to that existing law. We've had an example here in a Texas election of a still image that was created and it wasn't able to be prosecuted under the existing law. So that's a great addition that we've got there. To your point, sir, about the 30-day requirement, I think the intent requirement is going to get us there, right? We had an intent requirement in the definition of deepfake, and we're moving it to the offense itself, which makes sense, right? A deepfake isn't a deepfake by virtue of the intent of the creator, but because it was created with AI technology. So putting that intent requirement in the offense itself makes a lot of sense. We've also got an affirmative defense, right, if there is a clear label on the image. So it's a great bill, and Senator Johnson, appreciate you bringing it. Thank you.
And thanks for your testimony. Senators, any questions for any of these witnesses? And Ms. Siebert, you've testified many times. We always enjoy you. I've never asked you, are you related to the former State Representative Siebert from the Belton area? It's not a very common name. I was just curious. He's a great guy. It's okay.
And we say our name different, Seibert.
Ah.
I always say Siebert Rumware, but they, So anyways, but no, my husband's family was from Ohio, I believe. So, yeah.
Well, thank you. It's always good to have you.
Thank you,
Bless
sir.
you. It's good to have each of you. Thank you for being here. You're excused.
Thank you for pulling back the chair. I appreciate that. I'm sorry.
Thanks. Call Emily French. Chair calls Emily French. Emily is the last witness we have registered to testify on, for, or against Senate Bill 893. If anyone present wishes to testify on, for, or against Senate Bill 893, please come down and let us know. Ms. French, welcome back. Introduce yourself. Give us your testimony.
Good morning. I'm Emily E.B. French. I'm representing Common Cause Texas today in support of Senate Bill 893. I like to think of myself as a digital native, but lately I'm spending more and more time counting the fingers in the video, trying to see, is this an AI video, is this a deep fake, and teaching certain members of my family to do the same. The technology to create a deep fake is becoming more and more accessible every day, and it's important that we shield our elections from this AI-generated disinformation. As previous witnesses noted, of course, well-known candidates for state and federal offices often have the staff, money, and press connections to fight back against these things, but smaller candidates for local offices would have a much harder time coming up with the time and resources to do so. This bill takes a really important step toward leveling that playing field for all parties and candidates in Texas. Texans deserve to make their electoral decisions based on truth, and this bill will go a long way toward realizing that goal. We hope to see it pass. Thank you.
Thanks for your testimony. Senators, any questions for Ms. French? Thanks for being here.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 893? Seeing and hearing none, public testimony is closed. The bill is left pending at this time. Thanks, Senator Johnson. We're going to stand at ease for just a couple of moments while our Senate media experts make sure our sound is being broadcast over the internet for those watching. So we'll stand at ease for just a couple of minutes.
Testing, 1, 2. Testing, 1, 2.
Number 6, 6. Well, welcome back. The Senate Committee on State Affairs will come to order. The chair now lays out Senate Bill 875, and recognizes its author, Senator Birdwell, to explain the measure. Senator.
Thank you, Mr. Chairman, and members. Members, currently under state law, Texas school officials may not use public resources to advocate for or against a political party, candidate, or measure. In February of 2024, Denton Independent School District was sued by the Attorney General, alleging that 2 elementary school principals violated state law by encouraging their staff members to vote for certain political candidates in the March Republican primary election. Both principals stated within their office or within their official emails that they would have allotted 30 minutes of coverage for employees to vote during the primary election. However, the 2 principals were not penalized for their action because while it is currently illegal for school officials to use public resources to advocate for or against particular political parties, candidates, or measures, there were no penalties for such violations. SB 875 prohibits school officials from using independent school district resources or property to influence the outcome of an election or to persuade ISD employees to vote for a particular party, candidate, or measure. To address this issue, the bill creates misdemeanor criminal offenses if a school board member, superintendent, or principal violates this prohibition. If a member of the school board or superintendent uses funds or independent school district resources, including district email, telephone, mailing list, or property to electioneer for or against any political party, candidate, or measure, they are eligible to receive a Class A misdemeanor. In addition, SB 875 establishes a Class B misdemeanor if the chief administrator of an independent school district campus, a superintendent or principal, knowingly permits the posting of political signs for a period longer than 48 hours. If a school campus is a polling location, political signs are permitted during voting periods and will not be at risk of receiving such a criminal penalty. Thank you, Mr. Chairman. I'm happy to answer any questions, and I do know we have a resource witness that I do wish to call at the proper time from the Attorney General's office, Mr. Chairman.
Very good. Thank you, Senator Birdwell. Senator Perry, you're recognized.
Thank you, Mr. Chair, and thank you, Senator Birdwell, for this, Chairman Birdwell. So school districts can't use public resources. I would suspect that municipals, county, anything that's taxpayer funded is not supposed to use their resources for that, correct?
I believe that to be correct, but I did not include,
I know you
think
did
that'd be a
not.
two-subject violation, and so I was
I'm
trying to
asking-
address the Attorney General's concern of what he dealt with.
I
And
appreciate, I don't know if it is or isn't, but I find myself being so prescriptive and so strategic in bill filings down here that we leave one door open as we close another one, and that we come back next session and have filed multiple bills to correct that. So supporting the bill, we'll vote for the bill. If between now and the floor vote, potentially if we could find a way that would not violate a two-subject rule, because it's all under the same genre of elections. It's all, you can't use public resource. Public resource is attached to, whatever vehicle of the day, jury or political subdivision they're attached to. It would sure be nice to close that loophole, if you will.
That's correct.
Across the board and not have to come back for the next 4 sessions and do individual shotgun bills. So I'm going to have my guys look with your guys and see if it's possible. Not going to screw your bill up, but at the same time, let's close the door.
let's work together. We'll check with our parliamentarian and the Attorney General's office, and that way it doesn't get over there and their
No, I hear you.
parliamentarian says no, so.
I hear you. We'll work on both sides to make sure it's good, and if it's not, then that's okay. We got our answer, right? Bill file dates are Friday.
Yes, sir. Hoo-ah.
Thank you, Senator Perry. Senator Hinojosa, you are recognized.
Thank you, Mr. Chairman. Thank you, Mr. Birdwell. I think this is a great bill. Just a couple of questions to see if you're able to define this, and if not, I'd be happy to ask your resource witness. But you said using school resources, and this actually happened in my campaign. So would school resources also apply to a superintendent or principal's office where they may record an endorsement of something?
I believe that would already be covered. I've not seen that happen at the school district level, but I have seen where somebody makes a video in their taxpayer-funded facility, in fact, here in the Capitol, and made a video for a partisan reason or an endorsement reason that later the Ethics Commission made it an assessment. My belief is that that office is a public resource. That superintendent, principal, teacher does not own the office in the same way you and I do not own the seats that we sit on this floor. We are the steward of it. It would violate the principles of that stewardship to use your office to make a video.
Okay, and then obviously this doesn't take away anybody's First Amendment rights of expression or any of those kinds of things. So would resources also apply to a title? Like, for example, if, you know, a superintendent said, I'm endorsing XYZ candidate on their own, at their own home or somewhere else, would they be allowed to say so-and-so and then utilize their title, superintendent of XYZ school district?
It may be best to bring let me give you my first blush response, but I think our Attorney General's would be the better expertise to ask this question. What I'm trying to prevent is the misuse of these public resources for that partisan electioneering. What I think you're driving to is the undue influence. If I'm a superintendent and on my personal email, I tell somebody, I'm voting for so-and-so, that's not a violation of this statute should this be adopted and signed by the governor. What I'm not able to address here, because I tried to figure out, it's that undue influence of, is a senior telling a subordinate, not giving them an order, but creating an expectation on behalf of the senior to the subordinate. If it's done in a private email, this bill doesn't address that. It may be civil statute that does, because if that teacher then doesn't vote the way the superintendent said, this is how I'm going to vote, and the teacher presumes that there's an inference that I expect you to vote the same way, even if there's not an order in that email. That's a challenge that this bill doesn't deal with, and civil statute may already have, if they're dismissed from their job and they believe they were dismissed because they didn't vote a certain way. I don't address that here because I believe that's in a different chapter. Using a title, depending upon what they are endorsing, if they're endorsing something that is not political, maybe it's a product, maybe it's a home builder, maybe it's a, we just have a new superintendent, Granbury, just bought a new house, and, if it's an endorsement where their title identifies who they are, but the title is not meant to provide an undue influence of an area that they supervise or of people they supervise, I don't think that endorsement is a factor in the law either here or in civil statute elsewhere. But I would defer to the Attorney General's representative.
Yeah, no, I appreciate that, and that's a great answer. It helps me some, but I guess to hone it down is simply, obviously if an elected official is well known as an elected official, and they say, I say, hey, I'm Adam Hinojosa, and I endorse this person, that, that's still in my right to do that. However, saying I'm Adam Hinojosa, state senator, or, in this case, if it would be somebody saying I'm so-and-so superintendent of school and I'm endorsing, whether it's private or not, I don't know if that is included in the resources or not. And it's okay if it's not, I'm just asking the question.
Yeah, it's a great question. Let's ask the Attorney General's representative. Sure, thank you.
Any other questions for the author before we ask for our resource witness? Very well, we're going to open public testimony, and the chair calls Chief Ernest Garcia, Office of the Attorney General. who's here as a resource and can help with some of these questions. Chief, welcome. Introduce yourself. Tell us who you represent, and we'll have some questions for you.
Good morning, Mr. Chairman, Vice Chairman, members of the committee. My name is Ernest C. Garcia. I'm the Chief of the Administrative Law Division for the Texas Attorney General's Office, and I'm here as a resource witness.
Thank you. Get a little closer to the microphone, and I think Senator Birdwell has questions for you. Senator Birdwell.
Thank you. Thank you for joining, Mr. Garcia. Did you hear the question that Senator Hinojosa asked?
Yes.
Could you answer that question?
Yes, sir. My understanding is there's nothing explicitly that prohibits the use of a title with respect to a comment made. So the statute itself doesn't explicitly prohibit that, but the use of the title would certainly imply that the use of the title could be utilized to say how that person, who that person is, defines who that person is. But the actual use of the title itself does not necessarily constitute electioneering.
Okay. Let me ask this. Because in the political realm, as a political office holder, we do get asked sometimes to endorse candidates, both name and title. While a superintendent is not an elected official, would you have a recommendation for this bill to create such a preclusion?
Yes, sir.
Okay, so that the title may not be used, even though they're not a political officer. The board members, the board of trustees are political officers because they're elected. Then let me see how I can address that potentially in a committee substitute. My intent for the bill is to chill electioneering, but not chill the use of a public facility, a school district facility, for a candidate forum, or for, I'll give you an even better example. In my hometown in Granbury, we've used a local school auditorium for our county convention, whether it be Republican or Democrat. But I would also want to make sure that if my local Democrat Party wanted to have a candidate forum for sheriff's candidates, that a candidate forum being hosted by the school district as a facility is not considered a partisan act, because what I don't want to have is, some counties are blue, some counties are red, and you may have the incumbent has no challenger in a red county, but the blue county wants to have a candidate forum, wants to use the school auditorium for that candidate forum. There's no need for a candidate forum on the red side of the county, but you need a candidate forum on the blue side. Would hosting a candidate forum be considered a partisan event, even though it's not for the favor of a particular candidate? Would that be considered a partisan event? Do I need to put a protection in here for school districts to be able to host events that are not for singular candidates, but for candidate forums or candidate or party conventions? Would it be wise to put such a thing in this?
I don't believe a candidate forum would fall in the definition of electioneering, which is typically considered advocating for or against a candidate, a party, or a measure. So if it's a candidate forum and it's open to all the candidates, that is something that I believe would be permissible.
Should I put something in the bill that says that these preclusions do not prevent a school district from being the public host of a candidate forum or a county convention of delegates of any of the parties?
I'm certain a lot of folks would appreciate further, any additional clarity.
Okay. Thank you. We'll work on that together if it's all right.
Absolutely.
Thank you, sir. I appreciate it, Mr. Garcia. Thank you, Mr. Chairman.
Thanks, Senator Birdwell. Senator Paxton has questions. You're recognized.
Thank you, Mr. Chairman. And following up on Senator Birdwell's question, would, so a candidate forum, which is not favoring any particular candidate, and of course a municipal candidate forum is nonpartisan kind of by definition, but would it matter whether it were a general election candidate forum versus a primary candidate forum, which would be in a primary all one party? Would there be a distinction there? Or would you have to invite both parties if you offered it to one? Or
I think if you invited both, that would be fine. If it were limited to one party, then I agree with Senator Birdwell that further clarification would be helpful in the bill.
So that could go either direction. So the school district could offer the venue, but it could be that the school district didn't offer the venue, that the party reached out and only one part. So I'm thinking about in a primary, for example, or specifically. So if only one party reached out and the other party didn't reach out wanting to do that, would the school district have to offer that to the other? Or just to kind of parse down into all of the versions of that clarification so we get it right?
I think it probably would. Otherwise, it would look like maybe the school district was favoring a political party, which would run afoul of electioneering.
Mr. Chairman, may I respond to Senator Paxton?
Senator Birdwell, go ahead.
Thank you. What I want to chill is electioneering, but I don't want to chill using a public school building as a place for the public to meet.
Right.
So what I'm going to try to do, based upon Mr. Garcia's counsel, is put some things in that both relate to primary elections, general elections, and then things that aren't elections, but like county conventions to see who goes to the state conventions, so that a superintendent, a principal is not, okay, if there's any doubt, we just don't host anything.
Well, and I appreciate that, Senator Birdwell, because obviously our schools are public buildings, and so they've historically been used in these kinds of ways. So we wouldn't want to stop that. And I completely support. I just wanted to kind of bring up maybe one other version of the clarification that
We're going to tighten the shot group on this thing.
Thank you. Thank
You're
you, Senator
welcome.
Birdwell. Thank you, Mr. Chairman.
Thank you, Senator. Members, any other questions for Mr. Garcia? Thank you for being here. Thanks for helping us with this.
Thank you.
And the chair now calls Fran Rhodes. Fran Rhodes. And is there anyone else wishing to testify on, for, or against Senate Bill 875? If anyone else does wish to testify on, for, or against Senate Bill 875, please head over here to the table and let us know. Ms. Rose, welcome. We get set up there, then introduce yourself and give us your testimony. Close to the microphone.
My name is Fran Rhodes. I am president of True Texas Project. I am testifying today on Senate Bill 875 in favor. I am representing both myself and True Texas Project. We have fought this issue for a very long time, particularly in regard to school bonds that are on the ballots. And the schools, either the board or the administrators or the teachers, are using school district resources to try to influence people to vote for the bond. Something, Senator Birdwell, I'd love to see put in here is a better definition of electioneering, because they always claim we're only providing information, and that's legal. And yet it's worded so that, you know, this is for the children, you need to vote for this. In addition to that, oh yeah, no, I'm sorry, I already said that. I think it's definitely needed, and I appreciate your concern about using the school buildings, because you're right, we use those for lots of different things, as long as equal access is given to whatever group that needs them. So I just very strongly support this bill, and I urge passage. Thank you.
And thank you for your testimony. Senators, any questions for Ms. Rhodes? Thank you for being here. Is there anyone else present wishing to testify on, for, or against Senate Bill 875? Anyone on, for, or against Senate Bill 875? Seeing none, public testimony is closed. Bill's left pending at this time. The chair now lays out Senate Bill 406. 406 recognizes our colleague Senator Middleton to explain the measure. Senator.
Thank you, Mr. Chairman. Members, Senate Bill 406 ensures that Texas birth certificates remain accurate, consistent, and reflective of biological reality. A birth certificate, like a death certificate, is a snapshot in time that records accurate vital statistics existing at birth. A birth certificate states God-given sex, either XX or XY. President Trump has a nationwide executive order recognizing just two sexes, biological males and biological females, which expressly excludes gender identity. Governor Abbott has also signed an agency directive to follow the executive order and disregard court orders to change sex on birth certificates and driver's licenses. DPS and Department of State Health Services no longer recognize as unlawful court orders to amend sex on birth certificates that were not based in any state cause of action. And this bill reiterates in our state code that what Texas is already doing under the federal executive order and Governor Abbott's directive will stand. It also closes a loophole courts created with no authority to try and change vital statistics from the time of birth. This legislation is a necessary extension of the work we have already done in Texas to protect fairness in girls and women's sports and uphold the integrity of sex-based distinctions, work that began with Senate Bill 15 and House Bill 25 and Girls and Women's Privacy and Safety Acts. With the passage of HB 25 in the 87th session, we took a stand for female athletes in K through 12 sports by ensuring that students compete on teams that align with their biological sex as recorded on their birth certificate. In the 88th, we built upon that foundation with Senate Bill 15, expanding these protections to college athletics so that women at all levels of competition in Texas are not forced to compete against biological males. These bills were critical in safeguarding fairness, safety, opportunities, scholarships, and championships for female athletes. But as we have seen, the push to redefine sex in legal documents can create loopholes that could undermine these protections. Senate Bill 406 closes one of these loopholes by ensuring that birth certificates accurately reflect a person's biological sex at birth and cannot be amended to change this designation based on gender identity. Birth certificates are legal documents that serve as a foundation for sex-based protections in sports, medical care, and privacy laws. Texans overwhelmingly support keeping women's sports for women, and SB 406 ensures that our laws remain grounded in biological facts as well as protecting Title IX. Mr. Chairman, members of the committee, this bill is not about restricting anyone's personal expression. It is about ensuring that legal documents reflect accurate statistics and that our laws can be effectively enforced. By keeping birth certificates fact-based, we are taking another step to preserve fairness and integrity of women's sports and other sex-based protections, as well as safety for women in private spaces. With that, I yield for questions.
Thank you, Senator Middleton. Senator Hall, you're recognized.
Thank you, Mr. Chairman. Thank you for this bill. I think it's sorely needed. And your comment about we have executive orders covering this, we know that's only good for as long as the person who signed that executive order is in office. And so if we want this to be law for Texas, we've got to have this. It's a temporary protection. I commend our governor for recognizing the need to do this and stepping up with an executive order to fill the gap until we could get a bill like this passed, and I think that's good. The question I have is, does this extend to other official IDs? a driver's license, concealed carry license, fishing license, hunting license, anything else that the state issues, will that be covered by this?
Yes, the answer is yes, because, as you know, for example, driver's license, you have to produce a birth certificate. Well, what this bill would require is that it's your at-birth sex, right? That's what's going to be on your birth certificate. So yes, it would include that, or any other state license where you have to produce either your driver's license or your birth certificate. This bill is going to require that your at-birth sex is what's on those state documents.
Okay. The reason I asked, I couldn't find that in there. It's very clear on the birth certificate. And there's no question we need this, because we've had Health and Human Services sending requests to counties to change birth certificates, directives to tell them to change birth certificates. And this will put an end to that crazy practice. But I could not get from it, and if you tell me it's in there, that's fine, because I think it's important that this be a blanket for anything that anybody uses for an ID, that that's who they are.
Right, and I'll give you an example, like for college, you apply to college, you get your student ID. Well, when you apply, you got to turn over a copy of your birth certificate, right? So that would, translate into that further down the stream, right? That's downstream of the birth certificate issue, but this will ensure that happens.
The student would have said, well, here's my birth certificate, but I'm really not Bill Jones, I'm Janice Jones. And they issue a card, they will not be able to do that?
So you have to submit, as we went through in Senate Bill 15 and Senator Perry's HB 25, it's entered at or near the time of birth, right?
No, I understand it for the birth certificate, but when someone says, yeah, well, here's my birth certificate, this is who I am, but on this ID, I want to be known as you can put Bill on there, but put Janice in parentheses or whatever.
That may be a different issue if you're talking about, say, for example, private entities like private colleges and
state colleges.
Okay, state colleges, they have to.
Or any of the other IDs.
Right. Typically, with any sort of state license or application for a license or an ID in any form, you do have to submit your birth certificate. And this essentially would guarantee that downstream of making sure your birth certificate is accurately reflecting your sex at the time of birth. And then it would essentially carry over into any of those future applications for state IDs and licenses as well.
Mm-hmm. And this would clearly stop any county, somebody coming in and say, I need to change I want a new birth certificate. They would not be able to do that.
That's correct. Right now, the only way to change sex is by court order, and this bill prohibits that.
Okay. Thank you, sir. Good.
Thanks, Senator Hall. So, Senator Middleton, so then by addressing this at the birth certificate level, that's the fount from which all these other licenses, IDs would flow. Is that accurate?
Correct. Yes. Yeah. Thank you, Chairman.
Thank you, Senator. Any other questions for the author? So we'll open testimony and call as a resource witness Tara Das, State Registrar of Vital Statistics from the Department of State Health Services, to help us walk through the practical effects of the bill. Das, take your time. Welcome. Glad you're here. Take a seat there, and when you get situated, introduce yourself. Tell us who you're with, and we'll have a couple of questions for you. Welcome.
Hi, my name is Tara Das. I'm the State Registrar from the Department of State Health Services, here as a resource witness.
Thank you, Ms. Dawson. Senator Hall, you're recognized.
Thank you for being here. My question is really straightforward. Currently, the Health and Human Services practice is somebody comes in and wants their birth certificate changed, you send an order to the county asking them to change the birth certificate. Will this bill put an end to that practice?
So currently, when someone needs to apply for an amendment to their birth certificate, it's only done at the state. And then when we approve that application to process the amendment to the birth certificate, we send to the local registrar, serves as the local official over that birth certificate. We send them a copy of it so they have the same record on file that we do. So with this bill, we would process at the state amendments in alignment with this bill and then send to the local registrar the version so that they can issue that. Local registrars do not amend birth certificates independent of the state.
No, I understand, but they've been receiving instructions from you to amend them.
They receive a copy of the amended birth certificate, so they have the same record on file that we do.
Oh, but with it, they're being told, that's what I've had from registrars, to issue the person a new birth certificate and change their records, change their county records to reflect that change.
Yes, because all local registrars are to maintain a duplicate set of records to what we have at the state.
Okay.
So that's true across.
Will this bill end that practice?
We will continue to, every time that we approve an amendment to a birth or a death certificate, send to the local so they have the same copy to issue.
Will you be able to, with this bill passed, will you still be able to amend a birth certificate to change a person's gender identification?
So we do not collect gender on the birth certificate, we collect sex, and with this bill,
Excuse me, their sex. Will you be able to change their sex on their birth certificate?
In alignment with this bill, because it allows for changing the sex for clerical errors, or if the sex, I think, was ambiguous or unknown at the time of birth. That's in the bill.
You can only change it for clerical errors?
Correct.
Okay. So that going forward, this bill will put an end to people being able to change that on their own, coming to you. Okay.
Correct.
That's my question.
Okay.
That's what, make sure that we've got a bill that's doing what we want it to do, what Senator Milton intends for it to do.
Senator Hall, thank you. Members, any other questions for Ms. Doss? Thanks for your testimony. Thanks for being here.
Thank you.
Well, the chair opens invited testimony and call Vanessa Savage. Vanessa Savage for Senate Bill 406. And after we hear from Ms. Savage, we will open up public testimony and begin to call witnesses. So if you've registered to testify on, for, or against Senate Bill 406, please make your way into the Senate chamber so that we can hear from you in a few minutes. Ms. Savage, welcome. Introduce yourself, get close to that mic, and give us your testimony.
Thank you so much for having me today. Good morning, members of the committee. My name is Vanessa Savage, and it is my honor to testify in support of Senate Bill 406. I am a pediatric nurse with 10 years of experience caring for the health, safety, and well-being of children. I'm also the founder and president of Protecting Texas Children. For the past 6 years, I worked as a nurse at Texas Children's Hospital in Houston, the #1 pediatric hospital in the United States. Last year, I came forward to sound the alarm after seeing a pattern of deceit, illegal billing, and fraudulent misdiagnosing at the hospital. I blew the whistle to reveal how Texas Children's Hospital had not only lied about the existence of their transgender program, but were actively, illegally using Texas Medicaid funds to cover irreversible gender transition procedures for minors. A large part of my testimony revolved around the particular and specific ways in which the hospital defrauded Texas Medicaid insurance programs, which brings me to my testimony today. One of the ways that the hospital concealed their illegal billing of hormones to Medicaid was through this loophole in Texas law allowing anyone to change their sex on their birth certificate. I saw dozens of examples during my day-to-day in which the sex listed on the patient's official medical record was their preferred gender identity and not reflective of the biological sex they were born with. For some of you, this reality is hard to believe. How is it possible that a multi-million-dollar medical institution with global recognition would engage in deceitful manipulation of a person's sexual identity by ignoring biological realities? I can assure you this was happening in plain sight, and the reason for this was to avoid detection by Texas Medicaid insurance companies. When a child has an incorrect sex on file who is simultaneously receiving a cross-sex hormone for a false diagnosis like estrogen deficiency or a testosterone deficiency, this web of lies makes it unbelievably difficult for insurance companies to detect fraud. Imagine for a moment with me that a child is rushed into the emergency room with a life-threatening emergency where time is of the essence. The attending doctor reviews the chart for the two most important facts about the patient in front of him: the age and the sex. In the medical profession, these two fundamental characteristics about the patient determines everything, including the personalized and specific course of treatment and the dosage of medication prescribed. Imagine the disastrous, life-threatening, and unsafe consequences that would ensue from a doctor treating a male instead of a female, or vice versa, all because the patient was permitted by law to change their birth certificate to reflect their preferred gender identity. The patient would undoubtedly be harmed as a result. Currently, Texas law permits individuals to amend their birth certificate to reflect their gender identity, but Senate Bill 406 corrects this by mandating that birth certificates record an individual's biological sex at birth, defined in three ways: by physical characteristics, chromosomes, or endogenous profiles. This bill restricts changes to the recorded sex unless correcting a clerical error or when the sex was initially undetermined due to atypical or ambiguous characteristics. This ensures that birth certificates accurately reflect biological sex, which will result not only in greater transparency in our medical institutions, but most importantly in safe patient outcomes. This bill, if passed, would literally save lives. Thank you.
And thank you for your testimony. Senators, any questions for our witness? Thank you for being here. Thank you for sharing your story with us. We'll open public testimony on Senate Bill 406, and the chair calls Paul Hale, Denise Siebert, Kelly Niedert, Amanda McLaughlin, Landon Ritchie. So we got Mr. Hale, we got Ms. Siebert. We're looking for Kelly Niedert, Amanda McLaughlin, Landon Ritchie. All right, we'll begin on my left, your right. Ms. Siebert, welcome back. When you're on the end, you have to especially get close to the microphone because of where they are from the end of the table. So you've done it before. Introduce yourself. Give us your testimony. Welcome.
My name is Denise Seibert. I am representing myself. I am in support of SB 406. Thank you, Senator Middleton, for this bill. Thank you, senators, for hearing me today. We should always have the biological sex on the birth certificate. You can't change your DNA or chromosomes, neither by surgery or drugs. Some may believe they are the opposite sex or sexually fluid, but nothing can change your DNA or chromosomes. While watching Shark Week a few years ago, the narrator described a shark as it's a male shark, easily identifiable by two reproductive organs on the underside called claspers. We don't deny sex of animals. Why do we ignore the truth of human sexual organs or body parts at birth? It isn't assigned at birth. We are created male and female. Genesis 1:27, so God created man in his image. In the image of him, he created, of God, he created him. Male and female, he created them. Feelings change, but our biological sex and DNA and chromosomes don't. Allowing people to change their sex on their birth certificate is harmful and dangerous for people of the opposite sex. Males claiming to be females are endangering women and girls as their private spaces are invaded by males. I had a male come into a women's shower facility at a Corps of Engineers there in Stillhouse Lake to hang out with his lady friend. All I had was a shower curtain between me and him. I felt violated. My privacy was taken away from me, and I was scared to even scream because what would he do to me? Then during the last legislative session, I had a man dressed as a woman into the women's bathroom here at the Capitol. Why do I, as a biological woman, give up my rights and privacy and safety because males want to feel like a woman? Thank you for hearing me today.
Ms. Seibert, thank you for your testimony. Mr. Hale, welcome back. Introduce yourself. Give us your testimony.
My name is Paul Hale. I'm from Cass County. I'm representing myself and my household, and I am for this bill, and I want to thank the committee and our committee chairman, Senator Hughes, for allowing me to testify, and thank you, Senator Middleton, for bringing this bill. I am for this bill. First of all, and how important of a bill it is. It's the very first document, this birth certificate that he mentions here. It's the very first document in a person's life. That makes it so important. And so that cornerstone document that so many more will spring from has so much importance, and for all the obvious reasons that we see in the so-called woke movement that brings so much confusion in our culture, in our colleges, in our schools, in our politics, and so many more. And it is the most distinguishing thing about a child, those two organs. And then there's that other trail. But Senator Middleton was so complete with this bill because he thought of those other things, and he addressed those tough questions that come. And I don't understand those things, but he addressed them, and they're there. And this thing is completely fair. But the most important thing is a little infant baby deserves this, and he deserves to have his beginning document start on a foundation of truth instead of underneath a cloud of confusion. I thank y'all very much for letting me testify today.
Thank you, Mr. Hale. Thanks for your testimony. Welcome. Introduce yourself. Give us your testimony.
Yeah. Name is Amanda McLaughlin. I'm here representing myself. I am against the bill. I thank you for taking the time to listen to me. I'm Amanda McLaughlin, and I am a woman. Documentation is important for employment, business transactions, safety, and mental health. Being outed because documentation does not affirm who you are can lead to job loss, mental health issues, harassment, and safety issues. This bill states biological sex is determined by sex organs, chromosomes, and endogenous profile. It is well documented that many people have ambiguous sex organs. Many people do not have XX or XY chromosomes. The bill even admits it may not be possible to tell a baby's gender at birth, and provides a provision to add this designation for sex later. This bill shows the difficulty of defining biological sex and how subjective it is. This bill is an attack on transgender people. I ask why society works so hard to villainize and hate me. What do they fear? I'm a human being. I want the same things as everyone. I'm not a monster. This is not a fetish for me, nor did I wake up one day and decide to be a woman. I've always been a woman. I sacrificed a good career and 13-year relationship to be the woman I am. I can't imagine living as anyone other than Amanda. I have gone to doctors, psychiatrists, courts, counselors that all confirm that I am a woman. There is so much hatred from people who don't know us. It is easy to dehumanize and demonize people when you don't know them. People are motivated by fear when they don't understand. How many of you know a transgender person? If you don't get to know us, have a conversation with a transgender person. Rather than fear that we don't understand, we should try to grow. We have learned that the world is round and people with epilepsy are not possessed by the devil. Our lives are so much richer when we are open to growing. I thank you for listening and ask you not to advance Senate Bill 406 so that transgender people are not rejected or harassed because of documentation that doesn't match who they are.
And thank you, Ms. McLaughlin. Thanks for your testimony. Welcome, introduce yourself and go ahead.
Hello, my name is Kelly Neidert, and I'm the Executive Director of Texas Coalition for Kids. Thank you for this opportunity to testify in support of Senate Bill 406, which is critical to maintaining integrity of official records and protecting students in Texas schools. In January, administrators in Dallas ISD and Irving ISD were caught advising on legal loopholes that would allow students that identify as transgender to play in sports teams opposite their actual sex. These administrators specifically identified changing a student's birth certificate as a way to bypass existing policies. This blatant manipulation of legal records underscores why this legislation is needed. Birth certificates are foundational legal records that must reflect biological reality, not subjective identity claims. Allowing them to be altered undermines their accuracy and enables policies that create unfair advantages in sports and other areas where sex-based distinctions exist for a reason. Without this bill, students, especially girls in sports, will continue to face situations that compromise their safety and competitive opportunities. Passing this bill affirms truth, fairness, and secures the well-being of students. Thank you for your time.
And thank you for your testimony. Welcome, introduce yourself, get close to the mic, and give us your testimony.
Good morning, committee members. My name is Landon Ritchie. I'm the policy coordinator for TENT, the Transgender Education Network of Texas. I am a transgender man, and I'm speaking in opposition to SB 406. I want you just for a second to think about all the reasons you need a birth certificate. For folks who are afforded the privilege of being able to navigate life without having to think about what their identity documents say, because of this, pinpointing those issues may not come easily. So here's a quick list. You need a birth certificate in any instance where you need to prove your identity, age, or citizenship. When applying for government-issued IDs like a passport book, card, driver's license, replacement social security card. Applying for government benefits, registering a child in a new school or transferring schools, joining the military, joining sports, accessing pension or insurance benefits, proving your identity to banks, proving your identity to prospective employers, and more. Now imagine not possessing a form of government identification that accurately reflects your person. You're left with two options: avoiding partaking in many aspects of public life so as to reduce the frequency of instances in which you are forced to out yourself, or presenting documentation that conflicts with other forms of ID that are in alignment with who you are. The end result is isolation, the incentive for others to discriminate against you, and the placement of targets on the backs of an already vulnerable group of people. When trans and gender expansive and intersex folks cannot make necessary and reasonable changes to their birth certificates, while other demographics of people are still afforded the ability to do so through clerical changes, not only does the government violate equal protection under the law, but it sanctions transphobic violence by encouraging outright disregard for trans life. Bills such as this encourage a sick fixation with trans people's bodies and lives and mandating cruelty through bureaucracy. But try as this legislature might, transgender people will not cease to exist, and our existence is not up for debate. I urge you to vote against SB 406.
And thank you for your testimony. Senators, any questions for any of our witnesses? We thank each of you for being here. You're excused. Thank you very much. Continuing public testimony on Senate Bill 406, the chair calls Megan Benton, Autumn Lawner, Megan Fairbanks, Krista Gaston, and Alan Morris. Again, it looks like we have Ms. Benton looking for Autumn Lawner, Megan Fairbanks, Krista Gaston, Alan Morris. And the chair calls Emily French. All right. Welcome. We'll start over on my left, your right. Welcome back. Introduce yourself. Give us your testimony.
Thank you, Chairman and members of the committee. My name is Megan Benton. I'm the Strategic Policy Associate for Texas Values. I'm here to testify in favor of Senate Bill 406. Texas Values is the largest organization in the state of Texas standing for faith, family, and freedom. I want to express my gratitude to the committee and Senator Middleton for taking the time to address this important issue. Birth certificates are important legal documents, and their accuracy is something that should be taken seriously. Inaccurate birth certificates have real-life consequences that put women and children in vulnerable positions. In recent years, this has become an issue as some have tried to alter the integrity of his or her birth certificate in order to fit it with a desired gender identity rather than biological reality. Frankly, this is a matter of public safety and public record. If a man can legally change his birth certificate to say he is a woman, then it's possible to get a driver's license, passport, and social security card that also say he's female. Last year, the Texas Department of Public Safety stopped allowing people to change their sex on a driver's license by getting a court order or altered birth certificate. This action helped to rectify the problem, but this bill would help make these policies permanent. With a government identification card that contains inaccurate information regarding a person's sex, the door is wide open for criminal activity and unfairness. For example, a biological male may be able to access women's facilities while women are using them. This is a violation of the rights of women and children and must be addressed. Women should feel safe to use the restroom, locker room, or shelter without having to worry about a man walking in. Another example of how an altered birth certificate causes harm is women and girls sports. Having inaccurate legal documents can lead to great confusion. By passing SB 402, you will be providing much-needed clarity to the current situation. We don't allow people to change their birth certificate, their age on their birth certificate, so why would we allow someone to change their gender? SB 406 makes it crystal clear that it's vital to public safety to have an accurate birth certificate in the state of Texas. Thank you.
Thanks for your testimony. Ms. French, welcome back. Introduce yourself and go ahead.
I'm Emily E.B. French for Common Cause Texas. I am here to testify in opposition to SB 406. There has been a push at both the state and federal level to require documentary proof of citizenship to register to vote. This is highly relevant to SB 406. Neither this legislature nor any other will ever be able to stop transgender people from existing. If they exist as citizens of our nation and our state, they must be able to vote. I am worried that this bill will work in conjunction with a documentary proof of citizenship bill to disenfranchise transgender Texans. If we reach a point where each citizen has to show their birth certificate to register to vote, and a person who lives and presents as a woman is forced to show a birth certificate that lists her as male, will the election official or DPS officer who reviews that birth certificate have to mark it as fraudulent? Will the transgender individual be required to bring in additional proof that they are transgender? Will that additional proof be illegal before too long? Could a person be found in violation of any of the new or existing criminal penalties for voter fraud simply for using an ID that does not match the gender on their birth certificate? What is this legislature's plan to preserve the voting rights of transgender Texans under SB 406? I would like to see this bill voted down, but at the bare minimum, you must not pass this bill without protections for the voting rights of transgender Texans. Otherwise, we will be forced to conclude that disenfranchising trans voters is not a bug of this bill, but a feature. Thank you.
And thanks for your testimony. Welcome. Introduce yourself. Go ahead.
Good morning. My name is Alan Morris. I'm the Director of Policy for the National LGBTQ Task Force. Today I come to you as someone from Beaumont, Texas. I am leading a policy department that is navigating many things. We are in opposition of Senate Bill 406. And I want to appeal to each of you to humanize this situation, to see trans and intersex people as your neighbors and as individuals who deserve dignity. A vote for this bill is a vote of conscience, and it is a vote towards your legacy on how you viewed each individual and their humanization aspects. This proposed legislation has dangerous consequences, such as violence, discrimination, and misgendering. No one deserves to be mistreated, even in the midst of principled struggle. And I'm sure you all may have never heard of principled struggle. We may not agree on what it may look like, but we have to agree that humans deserve the dignity to live and exist and have documentation that identifies with what they want, right? Even in the midst of the approach or how you may see it. Furthermore, rather than documents that are able to physically name who an individual is, I want each of you to consider what your children or what someone who you love may have to deal with if in the event they may not have that documentation. Similar to Black people in this country who were not given birth certificates nor who were seen as citizens after building this country. And I want each of you to lean in to what it means to say, I'm going to go against the grain, and I'm going to say that I'm going to humanize these individuals, even though I may not understand it. Thank you.
Thank you for your testimony. Welcome. Introduce yourself and go ahead.
Good afternoon. My name is Autumn Launer. I'm a transgender Texan. I'm also the vice president of the Texas Transgender Non-Discrimination Scholars, here testifying for myself as well as our organization in opposition of SB 406. Simply put, this bill is a solution in search of a problem. It creates barriers without solving anything, making it more difficult for transgender Texans to access education, employment, and housing. A mismatched birth certificate creates confusion and blocks stability. Transgender students without accurate IDs face bureaucratic obstacles that block college enrollment and financial aid, limiting our future opportunities. Research shows that transgender people denied accurate IDs face higher rates of job loss, housing insecurity, and financial instability. A 2020 study published in The Lancet found that those with updated IDs had lower rates of psychological distress and suicidal ideation, reinforcing that legal recognition is a public health issue. A 2021 study on transgender Texans found that updated IDs reduced the likelihood of job discrimination, eviction, and homelessness. SB 406 traps people in instability, blocking access to financial aid, jobs, and housing while worsening mental health. Despite this evidence, we're here debating whether to weaponize government overreach to cause tangible harms to Texans instead of addressing real problems. This bill does not strengthen our state, it weakens it. It pushes people out of education, harms our workforce, and creates barriers to stable housing while worsening mental health outcomes. Texas is better than abusing state power to restrict its citizens' freedom for the sake of virtue signaling to billionaires in Washington. Reject this bill. Harming Texans does not make Texas stronger. Thank you.
Thank you for your testimony. And welcome. Get close to the mic and introduce yourself. Go ahead.
Good morning, members of the committee, and thank you for the opportunity to testify this morning. My name is Megan Fairbanks. I'm from Houston, Texas, and I'm here this morning to register my opposition to SB 406. I'd also like to state for the record that I'm not a shark. I'm a transgender woman. While I've known that I was different since the age of 13, I didn't start my transition until the age of 47. Transition for me has been one of the scariest and most challenging things in my life that I have ever done. Despite those challenges, transition has absolutely been the best and most rewarding decision that I have ever made. I would need well more than the allotted time to tell you of all the ways that transition has positively affected my life. Part of my transition has included updating my birth certificate to align with the identity that I've always known myself to be. Although I wasn't born in Texas, Texas has been my home for the vast majority of my life. I'd prefer not to name the state that I was born in, but let's just say that it's a state that fought on the side of the Confederacy during the Civil War, a state whose leaders believe in values such as small government. I personally believe, as I'm sure many of you do as well, that government interference into the personal lives of private citizens should be held to a minimum. In the time since I've gotten my birth certificate changed, my birth state has even rolled back some of their restrictive policies that make it harder for folks like me to update their birth certificates. When we pass legislation, is it not with the intent of making folks' lives better or preventing harm? How is this bill doing any of that? I sit here before you as a person who has updated my birth certificate, and I ask you, what harm have I caused society? I don't play sports, and the only thing I want to do in the bathroom is use the bathroom and maybe touch up my makeup and wash my hands. This bill helps no one and only causes harm. It singles out a specific group of people who are already marginalized and face challenges that none of you could possibly imagine. I ask simply that you not vote to advance this bill out of committee. Thank you for your time.
And thank you for your testimony. Senators, any questions for any of our witnesses on this panel? Thank you each for being here. Thank you very much. You're excused. Thank you. The chair now calls Mary Elizabeth Castle, Krista Gaston, Angela Lapis, Spencer Cook, Ash Hall. Again, Mary Elizabeth Castle, Krista Gaston, Angela Lapis, Spencer Cook, Ash Hall, and Andrea Segovia. We'll begin over on my left, your right. There you are. Council, introduce yourself and go ahead.
Good morning, Chairman Hughes and members of the committee. My name is Mary Elizabeth Castle, and I'm the Director of Government Relations for Texas Values. It's appropriate and fitting that we're considering SB 406, and I'm testifying in favor of this bill during Women's History Month, as the conversation this session has centered around the definition of woman and how women are being erased. We have seen allowing a person to change their sex on their birth certificate has led to men pretending to be women to invade women's sports, restrooms, and sex-designated spaces. In fact, in some instances, proof of surgical procedures is not needed in order to have a court order. Before current action was taken by an agency, it was simply up to a Texas judge determination if an individual should have their sex on their birth certificate changed. In my handout that I gave you, and it'll be the first handout that's a one-pager, you will see just how simple the physician recommendation letter is to change your sex on documents in Travis County. Very little proof of transitioning is needed, which means a fully intact male could gain access to women's sex-specific spaces and opportunities. This also means an individual who lived a majority of their lives as a male could even participate in women's athletics, as Senator Middleton described. As we discussed last session, there are physical advantages that develop in early adolescence and late childhood that transition procedures cannot account for and would still make a male claiming to be a woman stronger and faster than a woman competing in the same sport. Most importantly, sex is not a social construct or feeling or opinion. Sex is based on the biological order of the world and is determined by an individual's reproductive organs and ability to reproduce. Animals are female or male, so are plants, and so are vegetables. Government documents should not reflect someone's opinion or feeling, but they must be accurate and state true biological reality. Both the Department of Public Safety and the Department of Health Services have already adopted official policies to stop sex change on birth certificates and driver's license, and this should be clear and established in Texas law, which is why SB 406 is needed. You can reference page 3 of my second handout for this information as what was done last summer and last fall by both of those agencies. Thank you for your time, and please vote in favor of SB 406.
And thank you for your testimony. Welcome. Introduce yourself and go ahead.
Good morning, committee members. My name is Andrea Segovia. I'm the Senior Policy Director at the Transgender Education Network of Texas. I'm speaking in opposition to SB 406. SB 406 attempts to enshrine gender discrimination into law by barring transgender, non-binary, and gender nonconforming people, including intersex people, from accessing government identification that reflects their person. This bill follows the Attorney General's lead from last fall, where he made his office's mission to stop people from amending their state identification documents to carry out his transphobic agenda. It also seems to be that folks on this committee and even the author of this bill do not realize what this bill actually does. Talking about name changes, bathrooms, locker rooms, or even what is currently occurring to trans Texans by DPS and other state agencies abusing their power is far beyond what this bill does. Obtaining legal documentation of who you are is not a legal loophole. Over 60% of the trans population in Texas do not have IDs that match who they are. It is not as simple as folks are portraying it to be. Since August of 2024, our organization has been talking to hundreds of trans Texans who are currently living in fear because of who they are does not authentically match because of who they are is not reflected by their state documents. No one in our state who contributes to bettering their community deserves this. Trans people deserve the same fairness and freedoms as every other Texan. Trans people are not harming anybody. The conversations that are happening here today and continue to occur in this Capitol are causing the true harm to trans Texans. I urge you to vote no on SB 406.
And thank you for your testimony. Welcome, introduce yourself and give us your testimony.
Hello, esteemed representatives of Texas, staff, and others in attendance.
And
My name is
get a little
Angela.
closer to the microphone so we can hear you, okay?
Okay. Hello, esteemed representatives of the Texas Senate, staff, and others in attendance. My name is Angela, proud Texan, speaking on behalf of myself. I am strongly opposed to SB 406. This bill, at its core, serves only to amplify discrimination against transgender Texans. The Texas birth certificate serves as a core identifying document necessary and/or sufficient to obtain other legal identification, such as a driver's license, U.S. passport, social security card, or other legally recognized forms of identification requisite for participation in society. We have had, up until recently, a legally verified and thoroughly vetted process for Texans to amend their sex marker on their birth certificate. The sudden inquisition into the validity of this process and parallel creation of SB 406 disproportionately and intentionally targets and discriminates against transgender Texans by denying them a birth certificate accurately reflecting their gender. It should not be viewed as fraudulent to want one's birth certificate to accurately reflect one's identity. On the contrary, amending the sex marker on the birth certificate allows transgender Texans fuller participation in society. Numerous studies have shown discriminatory and unequal access to health care, housing, and employment on the basis of being transgender. SB 406 would amplify discriminatory action by outing transgender persons seeking new employment, educational opportunities, and/or public or social services. To amend a birth certificate allows a transgender person to further amend previous or obtain new identifying documents that could mitigate discrimination based solely on the basis of being transgender. Population estimates show approximately 92,000 transgender persons in the state of Texas. So among the 29 million Texas residents, over 28 million have a birth certificate with sex marker that reflects and aligns with their gender identity. On the basis of sex, SB 406 would be viewed as discriminatory as it specifically prohibits the transgender community, but not the cisgender community, from having a birth certificate where sex accurately reflects gender. Esteemed representatives, I urge you to vote no to SB 406. Thank you.
Thank you for your testimony. Ash, welcome back. Introduce yourself. Give us your testimony.
Thank you. My name is Ash Hall. I use they, them pronouns. I represent myself and the ACLU of Texas, and I'm here against the bill. Not having accurate identity documents jeopardizes people's health and safety. This is a bill that maybe sounds innocuous, but really does have a lot of life and death implications and even like the ability to access basic services from our governments and from other institutions that we need to stay alive. When someone's ID doesn't reflect who they are, it can create dangerous encounters with police, employers, healthcare providers, and others by outing them as transgender, non-binary, or intersex, and it immediately can put us at risk of harassment, discrimination, bullying, and violence. In fact, the most recent survey done that asked trans people what happened when they were forced to show an ID that did not match their gender identity did show that 2% of those folks were actually subjected to physical violence. And that was a national survey. Texas is the capital for murder of trans people in the United States, especially Black transgender women. I don't think it would just be 2% if this bill passed into law. As it is, it's already dangerous for so many of us to navigate public spaces because of the environment that's been created by this political discussion that we are having about my community. We deserve a lot better than persecution from our government. We are not trying to commit fraud or to trick anybody about who we are. We are actually trying to tell you exactly who we are. And frankly, especially given that we are in this building and the way that this issue has been politicized over the years, every single person in this building has probably used a bathroom at this point with somebody who's transgender, and it turns out all of us were fine. My identity should be in line with my documents, and that goes for everybody here. It's a matter of safety, it's a matter of life and death in some cases, and it's a matter of being able to exist freely in the world and live the way everybody else gets to live.
And thanks for your testimony. welcome. Introduce yourself and get close to that microphone and go ahead.
Hello, thank you, Chair people. My name is Spencer Cook, here testifying opposition to SB 406. I am a Texas-born citizen, born in a hospital here in Austin. Throughout my life, I have gone through school and made friends with many transgender people, each of which have had their own difficulties accessing and getting access to what they need. Specifically, I have had people that have fought for years to get the proper documentation, years and years of fighting, people that still can't get that. I've know people who are too afraid to even get the proper documentation in the first place. And these people get politicized heavily into something that seems alien, but these are our workers, these are our friends, these are our family members, these are people that we love. These are people that are close to me personally. And going through school, there was a thing, GSA, Gay Straight Alliance or Gender Sexuality Alliance. It's a group of children, people that pay special attention to these laws, pay special attention to what goes on here in these courts. And I don't know if anyone's aware of this, but every time a piece of anti-trans legislation is passed, there is a spike in trans suicide. There is blood on people's hands here in this, in this building. And I know of many things personally that I will not discuss here. All I want to say is listen to trans people when they tell you how this bill affects them. This does not affect me. This does not, well, in some ways it does, but this does not affect many other people besides just this group of this minority group of people. And I would advocate that each person, each chairman here listens closely to what each trans person has had to say and what each trans person continues to say as more and more legislation continues to pass. Thank you for your time.
And thank you for your testimony. And thank you each for being here. Senator Perry, you have the panel.
Thank you, Mr. Chair, and to Ash, and I appreciate you. You're always ready. You come in and you do an admirable job for advocating. Here's a question, set the politics aside, and this is strictly, and I know you're not a physician, but obviously there are unique differences between male and female at birth that our medical system addresses it throughout the course of that individual's life. You know, breast cancer being one of those issues, or et cetera. So do you know if a trans woman or a trans male enters a physician's office if they're treated as their biological sex? Because that's where the DNA and the chromosomes and things, for instance, women don't have prostate cancer. So do you have, because when we talk about safety and studies and demographics and things, as our medical profession looks back and tries to do trend analysis and treatments and statistical research and stuff, so does a trans woman in a medical setting get treated as a biological male for treatment? Or I'm just asking, if you don't know, you don't know, and that's okay too. I'm just, you know, it's a foundational issue, right? That doesn't change through the life of a person.
I understand what you're asking. If the doctor's doing their job right, they treat the person as trans, and so they address the person by their name, by their pronouns. They get that medical history if there's been any sort of medical treatment that pertains to this person's gender identity. And then from there, you figure out, you know, exactly, you know, obviously this is a very intimate relationship, the doctor and the patient, but that doctor does have to figure out, you know, what this person's body is like and what treatments they may need and what kinds of, as you said, diseases they may need to look out for. But it doesn't have to change the way that that patient is treated as a person, as, you know, per their gender identity. And so to answer your question, it's true that cisgender women are very very much not going to be getting prostate cancer. Transgender women, they might. And that's simply the reality that we live in right now, and it doesn't have to be a big deal. A lot of doctors have figured it out already.
So based on that, it's possible for people that trans fully, surgical and other treatments all the way into the system, and what I'm hearing you say is it's possible they would not have exposure to those diseases that are unique to genders at birth, biological sex.
I think you may be misunderstanding. When I say transgender women, I mean somebody who's transitioned from male to female. And so even though that person has made that transition, they could still have prostate cancer. That's correct.
Right.
And in that case, the doctor doesn't just start treating that person like a man. What they do from there is they treat their patient the way that they want to be treated. They're just also making sure that that person is not going to get prostate cancer.
And with that, that's what I'm going to. There are legitimate differences at birth that can't be changed and that demand, not just in medical settings, but other settings in life. So I guess it's complicated, and I appreciate your perspective, but the reality of the day is there are unique differences that from a medical perspective, it's important to know biological sex so that it doesn't distort results in test and research and treatments in those environments.
And that may be, but that doesn't change that we can still treat people the way that they want to be treated and treat them as who they are.
Yep, go ahead. Get that microphone so we can hear you.
Thank you so much. As the Transgender Education Network of Texas, we've been involved in many study bases in terms of healthcare. Senator Perry, to your point. I would say that in talking to medical researchers, medical students, things like that, having trans people as a population that they can care for who they are actually makes their healthcare better because they're able to see differences, because they're able to catch things differently than maybe a cis male or cis female. It actually advances what you're talking about. I am from Houston. I understand like medical capital, especially worrying about cancer, right? And what we've learned really since 2015 is that when trans people are able to be a part of studies and things like that, their research actually goes further because every body is different, but the ability to see differences in a spectrum of people, right? Thinking about age range, so you have young people, you have elderly people. If we're talking about cancer, that affects their bodies differently. It's the same concept such as that. It's the ability to have a larger spectrum.
Thank you. Did you want to respond to Senator Perry's question? Please go ahead.
Senator Perry, so in addressing the question you posed, so yes, a transgender woman could get prostate cancer. However, within the medical literature and what the emerging data is showing is that when we look at the hormonal milieu of a transgender patient, after a certain time of being on stable hormone therapy, legally prescribed, supervised hormonal therapy, after an administration of 3 to 6 months at stable dosing, and essentially without additional comorbidities, that we see a change in laboratory values to reflect the expressed gender. In other words, so a transgender woman on hormone therapy, including estradiol and perhaps anti-androgens for a period of 3 to 6 months, on that stable hormonal therapy, their laboratory values, including their CBC, certain chemistries, certain liver tests, certain cardiac profiles, will actually be reflective of a cisgender woman, and vice versa for a transgender man. If they are on stable testosterone or other androgen therapy, after a period of 3 to 6 months, their laboratory test values will also reflect that of a cisgender man. And for the physician at that point, what they are now treating is they treat that patient based on the values, and so they would use the analogs for a cisgender man for that transgender man if they've been on the hormonal therapy for 6 months, and for the transgender woman on hormonal therapy for 6 months, they will use the analog and schemata for a cisgender woman for certain tests. In regards to the question about cancer, Yes, so in terms of prostate cancer for a transgender woman, curiously enough, one of the therapies for prostate cancer in cisgender men is actually hormonal therapy. So if a cisgender man does not get their prostate removed for prostate cancer, one of the treatment options is actually anti-androgens and estrogen, so which is actually very similar to the therapy given for transgender women who want to medically and pharmaceutically transition. So in that sense, what we're now learning is that the screening guidelines for cancer among transgender individuals with certain organs, so a transgender man who still has a cervix, we will still follow the recommended cancer screening guidelines for anyone with a cervix, including cisgender women and non-binary individuals with a cervix. For individuals with a prostate, regardless of them being a transgender woman, we will still follow the regular prostate screening guidelines that we have established for cisgender men. In terms of breast cancer, for transgender women on hormonal therapy who have undergone breast development, we are seeing emerging data suggesting a mammogram and other breast cancer screenings in transgender women similar to cisgender women with breast development. So the data in the medical literature is emerging, but we are seeing these changes in the treatment, in our understanding of the treatment, and how these hormones are actually shifting our paradigm of treating, and how we're actually essentially now melding the two of understanding of the cisgender hormonal profiles and how they can actually be applied to the transgender population after a period of stable hormonal therapy.
And thank you for your testimony. Senators, any other questions for any of our witnesses? Thank you each for being here. Thank you very much. You're excused. The chair calls Fran Rhodes, Corey Moore Luther, C.J. Grisham, Aaron Walter, and Brady Gray. Looking for, there's Fran Rhodes, Corey Moore Luther, C.J. Grisham, Aaron Walter, Brady Gray, please. Chair calls Biz Thornton. Biz Thornton. All right, that will take your time. We're fine. You got plenty of time. That will complete this panel. And so we'll begin over here on my left. I think that's Fran Rhodes over there. Ms. Rhodes, welcome back. Oh, hold on one second. There's a seat right here on the end. I'm sorry. You take your time. You get over there. You get set. We'll be ready for you in a few minutes. Ms. Rhodes, welcome back. Introduce yourself. Get close to that microphone and go ahead.
Thank you. My name is Fran Rhodes. I am president of True Texas Project, representing myself and True Texas Project in support of this bill. I'm not an expert on anything here. I am just an old-fashioned grandmother looking for common sense. I represent a lot of supporters throughout the state of Texas who are also searching for common sense in this crazy world that we live in. This bill is common sense. Sex is not a state of mind. It is a biological fact, and it should not be changed, and government should not embrace the idea that it can be changed. It cannot. God created us man and woman, and you can't change that. So please exercise your common sense and pass this bill. Thank you.
And thanks for your testimony. Welcome, introduce yourself, and go ahead.
Thank you. How's this for sound? Am I close enough?
Loud, thank you. Very good.
Okay.
Thank you for making sure.
Great. I first began working with Texas in 2019. I was recruited to consult on a hurricane response hub designed to increase capacity and communication across Texas.
Make sure and give us your name while you're give us your name too. Go ahead.
I'll end with my name if you're okay with that.
Just so we get it. You go ahead.
We'll get it. I was here, a part of a hurricane response hub designed to increase capacity with communication across Texas, Louisiana, Florida, Georgia, and Puerto Rico after the devastating 2017 hurricanes. That experience led me to consult on a Texas-specific effort exploring housing, employment, and mental health impacts on Texans experiencing the greatest vulnerabilities. In evaluating these proposed bills and this process, I feel appalled by the lack of consideration for the broader impact of even the proposal of these bills, not only on all Texans, but the irresponsible example this provides for the entire country. Every bill proposed by a single author is a waste of Texans' tax dollars. Every bill proposed by a single author means they did zero work to explore the harmful impact that bill could have on all of Texas. It's irresponsible, it's disrespectful, and it's lazy legislation. By proposing a single author bill, referring it to committee, and requiring everyday Texans to travel hours, spend hard-earned money on fuel, hotels, food, take time off of work, take kids out of school for their few precious minutes to testify, this is not governance. This is an abuse of power, and it's shameful. Recently, I rewatched a film based on a true story. There was a scene with this person in the middle of a bridge with a raging river underneath. There were people on either end of the bridge, all moving slowly towards the person on the edge. The person was slowly and calmly reminding them of their siblings, their parents, their colleagues, and friends who would miss them if they jumped. The person responded, "I'd rather live free or die." I'm here today advocating for suicide prevention and want to ensure every person in your districts are familiar with the suicide prevention hotline because these single author bills collectively increase suicide for everybody. I ask you to refocus your energy on infrastructure that will improve access to safe housing, stable employment, and affordable mental health care without fear of discrimination and harassment. Stop wasting taxpayer dollars by proposing irresponsible single author bills. The person on the bridge lived. They escaped an abusive relationship. They traveled to a place where they could safely change their name, change their clothes, and occasionally return to their siblings, cousins, parents, colleagues, and friends, and demanded to be called by their freed name, Harriet Tubman. My name is Corey Moore Luther, and I'm here representing myself as a small business owner, a sibling, a child, a grandchild, a colleague, and a friend, and I confidently oppose every bill proposed by only a single author, including 406, authored by Middleton. Thank you for your time.
Thanks for your testimony. Welcome. Introduce yourself. Go ahead.
Thank you, Senator. Thank you for this bill. Thank you, Senator Middleton. My name is CJ Grisham. I'm a civil rights attorney here in Texas, focusing mostly on First and Second Amendment. I want to talk, and I support this bill. I think I said that. You know, we, especially in the law, those of you that are attorneys know that there are things, there are exceptions to hearsay, which is like government documents. And they're also self-authenticating. So you have a birth certificate can be admitted without having to authenticate it because it's a self-authenticating document. So now what we're telling, if we don't have this bill, we're telling society that why are we self-authenticating something that isn't real? A man will never be a woman. A woman will never be a man. Now, there's absolutely nothing wrong with a man dressing up as a woman and pretending to be a woman. By all means, he can do that. There's nothing wrong with a woman dressing up as a man and pretending to be a man and doing surgeries to make herself look like a man or feel like a man. That's fine. Let her do that. What we don't have to do, and what this bill fixes, is forcing the rest of us to go along with the delusion that a person can be something that they're not, just because in their head they feel that way. There are a lot of legal implications why this bill is necessary, because again, we do have self-authenticating documents. And if you're at trial and you bring up something and they say this is a female, because the document says female, but the person's up there testifying saying, no, I'm a man, well, we have legal issues here. This fixes it. Everyone should be treated with respect, including the people who don't want to go along with the delusions of transgender ideology. And I urge passage of this bill.
And thanks for your testimony. Welcome. Introduce yourself. Go ahead.
Thank you. Brady Gray, testifying for the bill. Thank you, Chairman Hughes, members. My name is Brady Gray. I serve as president of Texas Family Project. At Family Project, we work every day to protect Texas children and strengthen families by engaging in cultural, community, and policy efforts that uphold the timeless values that Texans hold dear. One of the most important ways we do this is by standing for truth, especially when it comes to something as foundational as our biological sex. Grounding our laws in objective reality isn't just good policy, it's essential to preserving the truth of who we are as human beings. This bill is not only about biological accuracy, it's about honoring that truth. Psalm 139:14 says, I praise you, for I am fearfully and wonderfully made. Our identity is not something created by culture or driven by confusion. It is a divine gift from God, male and female, He created us. Preserving that truth on our most foundational legal document, the birth certificate, is not an act of discrimination, but one of dignity and clarity. Today, we face increasing pressures to redefine identity based on feelings instead of facts. According to the CDC, 0.002% of babies are born with ambiguous genitalia, yet we are being asked to rebuild our entire legal and social framework around rare exceptions and activist ideology. This bill wisely allows for flexibility in those very rare medical cases while protecting the integrity of the birth certificate from being used as a tool for ideological affirmation. Identity matters, and our public records must reflect truth, not political trends. As parents, we are called to lovingly guide our children, not affirm every passing feeling. As a society, we bear the responsibility to protect our kids from irreversible decisions rooted in confusion. And as Texans, we must remain clear. Biology is not bigotry, it's truth. I want to thank Senator Middleton for bringing this bill forward, and I urge each of you to support it. Let's ensure that Texas continues to affirm truth, honor God's design, and protect the integrity of identity from the very beginning of life. Thank you. I'm happy to answer any questions.
Thanks for your testimony. Welcome, and since you're on the end of the table, I'll remind you to get close to the microphone. Those seats are a little further apart. That's why on the end, I always remind folks, please do that. Welcome. Introduce yourself.
Hi, how am I on volume? Is that good? Okay. My name is Biz Thornton. I am here representing myself as well as the Texas Unitarian Universalist Justice Ministry, and I am opposed to this bill. Make no mistake, this bill will harm transgender people, and I'm here today to talk about just one way that this law will harm intersex Texans throughout the state. Approximately 1 in 2,000 babies are born with differences to their sexual anatomy, and these babies are intersex. Many parents are pressured and coerced into agreeing to completely unnecessary so-called corrective surgery on their newborn children, which can lead to lifelong psychological and physical pain and struggle. When parents are told that all babies are truly male or female and that some babies just need to be so-called corrected, and when parents feel legally forced to choose between male and female on their children's birth certificates, that adds to this pressure. I understand that you may believe that allowing for corrections to so-called clerical errors will allow intersex people to change their legal sex at some point, if necessary, in the future. But even if this were true, the legal necessity to choose male or female on the birth certificate already does harm. Please do not cement this pressure even further. Trans and intersex solidarity forever. Thank you.
And thank you for your testimony. Senators, any questions for any of our witnesses? Senator Hinojosa, you're recognized.
I just wanted to get the stats correct. Mr. Gray, you said that it was 0.002%. What was the stat you gave us?
According to the CDC, yes, sir.
CDC. And can you repeat that, please?
Say that again.
What was the stat?
0.002% of babies are born with what is considered ambiguous genitalia.
Okay. And then you had a stat too. What was your stat?
Yes, my statistic comes from Interact, it's an intersex advocacy organization.
And what was the stat?
1 in 2,000.
1 in 2,000. What?
Babies are born with differences in their sexual anatomy that may result in pressure to their parents to get this corrected.
Okay, and what was your source again?
What's that? Oh, my source is from Interact. They're an intersex advocacy organization.
Okay, thank you. Just wanted to get the stats.
Thank you, members. Any other questions for these witnesses? Thank each of you for being here. You're excused. The chair calls Aaron Walter. Aaron Walter Tracy Shannon. Aaron and Tracy are the last two witnesses come on down. That's the last two witnesses we have registered to testify on, for, or against Senate Bill 406. So if we've not called your name, please make your way down so that we can hear from you. And we'll begin on my left, your right. Introduce yourself, give us your testimony. Welcome.
I'm Tracy Shannon, and I'm here on behalf of myself, and I am testifying in favor of the bill. I'm a trans widow. In 2009, my husband's records were falsified to say that he was a female. The first thing he did was have his driver's license changed, not his birth certificate. So there is a problem with this bill. It will not correct this. We still need to close loopholes in the Texas Family Code and in the Texas Transportation Code. But I'll go on. We went to court where I found I was divorcing a legal female. Not only was I betrayed by my husband of 15 years, I was betrayed by the state that I love and call home. On paper, I was represented as a lesbian. I'm a Christian, and this violates tenets of my faith. Daily, I was threatened to have pronouns enforced or possibly be held in contempt of court. My ex has since gone on to use female restrooms, play female sports, and is a 4-time women's golf champion. He's been recognized as a woman of distinction in a male-dominated industry, all because a judge wrote an order to falsify his sex, prioritizing a man's feelings above his family and what is good for women. I was not, sorry, I said that. Falsification of sex is the golden ticket that allows men into female spaces, and it's more than bathrooms and sports. It's women-owned business certifications. It's grants, scholarships, and recognitions and awards for women. It's set-asides for women. It's professional, social, charitable organizations for women. It's intimate care, prisons, jails. Corrections officers are being forced to do searches on men who say they're women because they request a female. And females are asking for female carers, and they're getting men who have documents that say they're female. As long as there is legal falsification of sex, there are no female-only spaces or categories. Women are born, not made. A woman is not a feeling. Women are quite literally born this way. You can pass all the bills to protect a woman this and woman that, but until we end falsification of sex and reverse all these orders in Texas, there will be no female-only spaces. Sex mimics can use men's restrooms and freshen their makeup in the men's restrooms. Real women do not need prostate checks. Thank you.
Thank you for your testimony. Welcome. Introduce yourself. Go ahead.
Good morning. My name is the Reverend Aaron Walter, and I'm proud to serve as the Minister and Executive Director for the Texas Unitarian Universalist Justice Ministry and a board member for Texas Impact. I appreciate all of you and your time and your efforts as servants of the state of Texas. I'm a native Texan, a cisgender woman, and a mother, and I'm here in profound opposition to this bill, in solidarity with my trans and intersex friends and family, As a minister, I understand the pain, and I hear your pain, and I understand that there are a lot of perspectives on this. My perspective is that gender expansiveness and gender diversity has always been. Many religions recognize it, and mine does. So when we talk about a faith perspective, and we recognize the state of Texas recognizes the diversity of faith perspectives, mine opposes this bill. I'm here on behalf of Texans from 40 congregations across the state of Texas, Unitarian Universalist congregations from Dallas, Plano, San Antonio, El Paso, all around the state. And we ask you to please support our trans community and oppose Senate Bill 406. Thank you.
And thank you for your testimony. Senators, any questions for either of our witnesses? Thank you both for being here. Thank you very much. Those are all the witnesses who have registered to testify on for or against Senate Bill 406. So I'll ask, is there anyone present wishing to testify on, for, or against Senate Bill 406? Please come on down. Anyone else, please make your way down so that we can hear from you before public testimony closes. Go ahead and have a seat, and we'll get some details, then we'll let you of course, you'll be welcome to testify. Tell me your name.
Hi, can you hear me? Is this all right? My name is Abby Criswell.
Hold tight, Abby, just a moment. And thank you. We're going to get you a card to fill out just so we'll have a record of your testimony. Okay. You may have registered online, but it's not showing up, and we want to make sure you get to testify. So welcome. Introduce yourself and go ahead.
Hi, my name is Abby Criswell. I was born and raised in Texas, and I'm a very proud Texan. And I'm here to say that I am profoundly against this Senate bill, and I would like to speak more about that. So I came here today because I just can't stand for what this bill is trying to do to Texas and all Texans. It's a gross attack, I believe, on trans people and a significant overreach of government power, not something I believe in. I believe in a Texas where everybody has the basic freedom to exist and be who they are and communicate that to the world. And I don't believe that the government should have the power to tell people who they are or try to control that in any way. So I'm here to say that trans people have always existed, and this bill would be an effort to try to erase trans people, but trans people will continue to exist, and this bill will not change that. And I believe that it will only cause a lot of harm to the trans community. So I'm asking you to please not support this bill and to not harm Texans that are here and want to live here and be who they are.
And thank you for your testimony. And we did find your information, so no need to fill out a card. Thank you for registering. We've got you. Members, any questions for Abby? Thank you for being here. Please
Could
go
I
ahead.
actually add one more thing?
Well,
Is that all right?
Well, sure.
Okay.
You bet.
Thank you so much. I also wanted to say I was hearing other witnesses quote scripture about how women and men are, like, people are born as either women and men. And not only are women and men, that's like a gender thing, but female and male, I think, is what people were trying to say as like a sex thing. And as someone who is educated in biology, that's simply not true. So that's just fundamentally false. As a biologist, I'm here to tell you that. So just the sex categories of male and female don't capture the truth. So anyone who is saying this bill is about the truth, this bill is about supporting the truth, that's just not scientifically, factually correct. So I'm here to say that. And also, as someone who was raised Christian and has like pretty profound Christian beliefs, it really disappointed me to hear people quoting scripture in support of a bill that's going to cause so much harm and just, I believe, is so fundamentally not Christian and doesn't align with like my beliefs and what I believe Christianity to be. So I wanted to add that here. Thank you for hearing my testimony, And once again, I just wanted to plead with y'all to not support a bill that I believe will cause profound harm to Texans and the Texas community.
Okay, thank you for your testimony. Senator, is there any questions for Ms. Criswell? Thank you for being here. Is there anyone else wishing to testify on, for, or against Senate Bill 406? You're raising your hand to testify? Come on down, have a seat. We'll get your information.
Okay, hello. I am Mercado Rodriguez.
Hold on, pull that microphone a little closer to you.
Hello, I'm Mercado Rodriguez.
Hold on just a minute, Mr. Rodriguez. If you don't mind, before you leave, will you fill that out? You can go ahead and testify. If you promise me you'll fill that out and give it to us before you leave, okay?
Yes.
Welcome. Introduce yourself again and go ahead.
I am Mercado Rodriguez. And the thing is, I wanted to be able to testify towards this bill that's been going around because I've been pretty much strongly affected.
Get closer to that mic so we can hear you, okay?
I've been strongly affected because I am a trans man. And the thing is that living in a red state, and a red state in particular that has been, it's just, sir, I wish to speak to you directly.
You can do that, but if you speak into the microphone, we'll make sure it's on the record and everybody who's watching can hear you as well. If you want to have a private conversation, we can have a meeting in the office, but here we want to make sure your testimony is, if you want to testify on the bill, we want to make sure we can hear you. So go ahead.
No, I wish to speak to you directly, sir, when it comes to the bill. Please.
Okay, we can have a private conversation later, but if you're going to testify here, we want to be able to hear you. So you can decide, okay? I'm happy to meet with you privately, but if you're going to testify, we want to be able to, everybody needs to be able to hear you.
All right, then I'll testify. I'll talk to you afterwards.
You bet. Get that microphone closer so we can hear you.
Sorry, sir. I wish to speak with you directly afterwards.
That's fine. You bet. We'll do that. Go ahead.
Okay. Thank you.
Okay. Is there anyone else wishing to testify on, for, or against Senate Bill 406? Seeing and hearing none, public testimony is closed. Bill's left pending at this time.
Chair lays out Senate Bill 1539 and asks Senator Birdwell to explain the bill on behalf of Senator Bettencourt.
Thank you, Mr. Chairman. I appreciate the opportunity to return the favor that Senator Bettencourt's done for me on many an occasion. Members, Senate Bill 1539 addresses concerns raised by frivolous lawsuits being filed throughout Texas that could impact the implementation of constitutional amendments that the majority of the voters have approved. This could allow for approved constitutional amendments, such as last session, the largest tax cut in history, to get tied up in litigation. Senate Bill 1539 establishes that the filing of an election contest does not suspend the implementation of a constitutional amendment approved by the majority of the votes cast in the election. Thank you, Mr. Chairman and members. And I'll do my best to answer questions, but that we may have to defer questions to the actual author.
Correct. Any questions for Senator Birdwell regarding Senator Bettencourt's bill? None. Chair opens up public testimony on Senate Bill 1539. Chair calls Ed Johnson and Shannon Huggins That's the only two I showed registered for public testimony on Senate Bill 1539. If you're wishing to testify on it, please register during the time these two are up here so we can get you on board. Shannon Huggins and Ed Johnson. 2 minutes. State your name, and who you represent, position on the bill, and you have 2 minutes, Mr. Johnson.
Okay. Ed Johnson, with the Harris County Ballot Security Committee, and testifying here myself. We're in support of this bill. It's a really good bill. I was really upset when my property tax reduction did not go into effect last year. It took a whole nother year to put it into effect. And it was a very frivolous lawsuit that should not affect these constitutional amendments. In my work with elections, I have never seen a constitutional amendment vote that's ever close enough that an election contest would have any effect on it. Usually they win 60, 70%. That's a margin that you're not going to be able to change by election fraud or something like that. That's just statistically impossible. So I think this is a very good bill. I don't think it would have any negative impact to go ahead and implement these constitutional amendments. They have to be approved by y'all by 2/3 vote, so you have both parties voting for these constitutional amendments. So that's why they usually go through without too much opposition. Thank you.
Any questions for this witness, members? Thank you. You're dismissed. Shannon Huggins, calling one more time. Anybody else wishing to testify on, for, or against Senate Bill 1539? Chair hears none. Public testimony is closed. Leave that bill pending. Which one? 22. Chair calls up Senate Bill 1346, asks the bill author, Senator Hughes, to explain the bill.
Thank you, Mr. Chairman. Remember, Senate Bill 1346 deals with a topic that this committee has become very familiar with, and that is the Texas lottery and how it works, and the challenges we've had with folks trying to cheat and trying to buy all the combinations. There was a lot of testimony about that. Investigations are still ongoing. But this, again, we remember in April of 2023, when an international syndicate was able to purchase, effectively purchase the lottery jackpot of $95 million, getting a one-time payment by acquiring virtually all of the 25.8 million possible number combinations. The operation was planned internationally in Malta, funded by a London betting company, and carried out by a handful of Texas retailers, all connected to online sales companies called couriers. Again, this topic is a very big one this session, and this committee has taken action and will continue to. But clearly, this type of organized activity undermines the integrity and the fairness of the lottery. As we said, as we heard many times, Texans buying those tickets thought they had a chance at that jackpot, but they really didn't. So SB 1346 would prohibit the sale of lottery tickets to one or more persons who are attempting to purchase all possible winning tickets for the drawing. Lottery Commission must revoke a sales agent's license if they're found to be in violation. And an agent whose license has been revoked cannot apply for a new one until after the first anniversary of the revocation date. So at least a year they would have to sit out. We will have a committee substitute. It is not ready at this time, but we'll follow up with that later. Again, these issues are well familiar to this committee and folks who follow, and that's what the bill does. Now, I yield for your questions.
Any question for the bill author, Senator Hall?
Thank you, Mr. Chairman. Yes, sir. Thank you. This is a good bill. I agree with it. However,
One is, I think it should be lifetime, not a year. So when somebody's demonstrated that what they'll do, what they do, to just slap their hands and have them sit on the sideline for a year, I think it should be a lifetime. And this is good, but what I've learned in this is that there was a very, very, very smart people. This is just one way to cheat the system. And from what I've found, they're looked at, and there are multiple ways, and there are other ways that the system is being cheated. And this will take out one. But I think the only cure for the problem of the people of Texas being cheated out of money through the lottery system that we have is to end it. And if we find this kind of corruption in something as benign as the lottery system, think what kind of corruption and thievery we'll have of the people if we expand gambling here in Texas. I think this is a bellwether that ought to wake us up to the fact that there is no way when you enter this world in which there is huge amounts of money available, that there's going to attract those people who are looking for devious ways to make more than their fair share of it. And that's what happened, because this happened from the inside. This wasn't smart people on the outside figuring out how to beat the system. This was working within our government agencies to set it up so they could do it. And that was clear evidence when they put out their press release just before the hearing a couple of weeks ago, in which they admitted that the rule changes they made is what allowed this to happen. And so I commend you for this. I'm in full support of it, but I don't want us to fool ourselves in thinking we've fixed the cheating problem, the theft that's gone on against the Texas people by shutting down this one little piece of it. There are other parts out there that exist today that need to be shut down, and we need to seriously consider, do we want to set this up to have the people of Texas cheated with sports betting, internet netting, and casinos all over the state? Thank you.
Thank you.
Senator, you're right. This is part of a solution. You're right. Thank you. Please.
Any other questions for the bill author? I do have a resource witness from Commission, Lottery Commission. Is there any members for needing questions from the resource witness? All right. Chair opens up public testimony for SB 1346. I show roughly 9 registered for. No one wishing to testify publicly on that. Yes, Senator Hall.
Who's our resource?
Ryan Mendel, I think. Ryan Mendel.
Okay.
Okay. All right. Are these public? Okay. Denise Siebert, open up public testimony to Denise Siebert and Rob Kohler. Public testimony. Anyone else wishing to testify on, for, or against Senate Bill 1346 publicly, get registered to do so, and you can come in after these two panelists. Go ahead, Rob.
Good morning. My name is Rob Kohler. I'm here representing the Christian Life Commission of the Baptist General Convention of Texas. Members, as we all know, that $95 million jackpot was stolen from the citizens of this state, and that would not have been possible if the rule changes that the Texas Lottery made in 2020. To fix this problem, not only do we have to have a bill like this, but we need to go back and put the definition of the play slip back the way it was before they messed with it. That was take out electronic means from the definition of a play slip. We also need to get rid of the QR codes. When the Texas Lottery in 2015 went through their rulemaking, they created QR codes, and they told the public that this QR code was going to reside only in the Texas Lottery Commission's new informational app, and it would only be used by the players of this state for coupons. That's not what's happened. What's happened is these QR codes is how these couriers process the tickets. Not only were they able to, use them, and now that we know the stealing of the jackpot, the 25.8 million combinations in 72 hours, but as we speak right now, they're using these QR codes that they were never supposed to use in their commercial enterprise. And I'd represent to you that even this last jackpot, using this makes those tickets invalid. You may hear from the couriers that you're putting them out of business. I'm sorry they didn't come in here the right way. They should have come in here and asked for y'all's permission first and passed a piece of legislation. But at the end of the day, there's not a lot of difference between them and squatters. They came in here, they found a little loophole, and they nestled in here and tried to weave in our fabric of our state. But you can't operate that way in longevity. Thank you.
Thank you. I am going to call Ryan Mendel up to the witness stand. Members do have a couple of questions for the resource witness. Go ahead, ma'am.
My name is Denise Seibert, and I'm representing myself, and I'm in support of SB 1346. Thank you, Senator Brian Hughes, for this bill. Thank you, senators, for hearing me today. The scheme of buying of lottery tickets has gone rogue and needs to be stopped. Because of this technology these days, it's become harder to protect the lottery system and sales. The advantages of lottery sales are disappearing. I support this bill to regulate the lottery system, but I'm also asking to shut down the lottery. The cost of family and individuals has become too high. Gambling addiction costs lives, family, and finances. In my family alone, there are 2 members who have struggled and lost money because of their gambling addiction. My husband's addiction cost our family over $120,000 and 40 years of addiction of his life, and seriously affected the entire family. Before the internet and credit checks, he would hide the loans until I found them out. Gambling addiction is real and hurts everyone involved, even those near them. Shutting down the lottery, because I really doubt you could ever be able to catch those involved in lottery schemes these days, because it's become too easy to defraud. And so I support SB 1346. Hopefully you can protect the lottery if it continues. I'm not sure. So thank you for hearing me.
Mr. Mendel, state your name and who you're with.
Ryan Mendel, Executive Director, Texas Lottery Commission.
Mr. Mendel is the resource witness with the Texas Lottery Commission. Questions, members?
Yes, I do.
Go ahead, Senator All.
Thank you for being here. Back at the Finance Committee hearing and a couple other times, asked you about ending the couriers. And what was your answer?
At that time, and to this day, we don't have any regulatory jurisdiction over couriers, but we have regulatory jurisdiction over brick and mortar retailers that license us. And we now, as you know, have issued the policy statement that we're going to go after the licenses of the brick and mortar retailers that affiliate with couriers. At that time, that was not the policy.
I think your words, we have no authority. And they only operate because of the rules changes that the Lottery Commission made. And I believe you put out a press release a couple of weeks ago that listed several rule changes that put the couriers out of business. Do they not?
Senator, I believe that the press release referenced some of the statutory provisions that could potentially be violated by the couriers. That's
No, you had written, the commission had written rules that violated 466. You wrote rules allowing electronic interface, the telephone, and set up a system that was impossible to determine a person's age, just to mention a few of them. That had those rules changes not been made, would the couriers have been able to operate?
Senator, yes, I do believe so. And I know that, a lot of the...
How would they operate without the Q codes? How would they operate without the Lottery Commission specifically sending roughly 50 machines to 4 locations into just before the pot got to $95 million? Warehouses, not brick and mortar. The original legislation called for a brick and mortar, otherwise in business doing something. These were empty buildings in which just lottery machines were delivered. A few days before the 3 days, 72 hours, which they used the Q code that the rule changes allowed them to use to produce almost 26 million combinations to buy all the lottery tickets. And those all happened because of the rules that the commission had written. So tell me how they could have done that and why you felt, when you answered the question, said we have no authority to do anything about them, why you would say that when they only operated because of the rules the commission had changed, which allowed them to operate.
Senator, there's a lot there, so I would like to try to address a few of those points. So first, the terminal deployment process is not embodied in the rules. And so that was one of the first things that I changed when I became executive director, saying that the way that we deployed terminals in April 2023 was not appropriate. So we changed that. That did not require a rule change. That was
Not appropriate. But did anybody think that that was just not fitting? I mean, it was not. How many other locations had you delivered that many machines to?
To my knowledge, none. And again, that's why it was inappropriate, and that's why that was the first process change that I made when I became executive director.
Okay. Well, I think it was pretty obvious all the way along that the only reason the couriers were able to operate were because the Lottery Commission had written rules that violated 466. And those rules are the ones you're now proposing to change, which that's commendable. But the horses, to use the old Texas form, is the horse is out of the barn on that. In that. So anyway, thank you.
Thank you, Mr. Chair. Just to be clear, are couriers still operating today or not?
Senator, thank you. My understanding is that a number of them have ceased operations. We currently have enforcement actions pending against every retailer associated with a courier that we know of in Texas.
And that's due to a proposed or an actual rule change by the board today?
I'm sorry,
Is
Senator.
that due to the board's actions on a rule change? Is it being proposed or has it actually been approved today?
The new rule was approved by the board to go out for public comment. That won't be approved that. So what we found is violations by those retailers, either by using an inappropriate QR code or by not being in business of selling anything else. And
You're-
taking action to revoke those retailers'
Is it fair to state your board is committed to going back to, I think, 215, where all of this stuff was prohibited by rule and reversing the rules that gave them that? Is that a fair statement?
Absolutely. We proposed a set of rules in October that were approved by the board that are unwinding many of those. And I've already had a conversation with Mr. Kohler today. We plan to take another package after they approve these courier rules.
We can move on. He's got 5 bills to get done. One question, Senator Hall, one more. We've had this in finance, we've had this in here, and we've had it in the floor, so one more.
Just want to make sure. So why should we trust that the Lottery Commission, after the dust settles, a few months pass, done all this little cleanup, that folks within the commission will once again try to figure out a way to beat the system and cheat the public out of money like was done in the past? Why should we trust that that would not happen again?
Senator, I really appreciate the question. It's something that I'm very focused on, and that's why, since I've become executive director, we've changed the processes, we've updated the rules, we've now banned couriers and taking action against them. As long as I'm executive director, we are going to continue to work and be better and work on improving the trust both of the legislature and the public.
Okay,
Thank you, guys. All right, any other questions for this panel? All right, thank you, guys. You're dismissed. Anyone else wish to testify on, for, or against Senate Bill 1346? Any other public? Chair hears none. Public testimony is closed. Chair recognizes SCR 22 and recognizes the bill author, Senator Hughes, to explain the bill.
Thank you, Mr. Chairman, and thank you, members. Senate Concurrent Resolution 22 would designate the cannon as the state gun of Texas. The cannon has been an iconic symbol in our history, and of course, key in Texas' fight for independence. The Battle of Gonzales in 1835, the first conflict of our war for independence, 150 Texians refused to surrender their cannon, raising the flag, of course, with that famous phrase, "Come and take it." At the Battle of San Jacinto, the twin sisters played a key role in the defeat of Santa Anna's army. And in 1842, and my apologies to Houstonians for this next reference, but in 1842, Austin feared losing its capital status. An innkeeper named Angelina Eberly fired a cannon to alert the city and stop the removal of the archives. Today, of course, vintage cannons are found across the state at courthouses, historic sites. Firing a cannon is an important tradition for us, reminding us of our struggle for freedom and our shared heritage. This concurrent resolution is the same version that passed the Senate in the 85th legislature. SCR 22 designates the cannon as the state gun of Texas. And of course, I'll yield.
Any questions? Senator Birdwell.
Having recently been inducted into the United States Field Artillery Hall of Fame in the class of 2024, shall we discuss the difference between a cannon, a howitzer, a gun, and a mortar?
Since my application is going to be pending for a long time, I'm going to defer to whatever you say those terms mean, Mr. Chairman.
No, I did look at the bill, and one serious question: why an SCR? Is there a because it is, we have done resolutions in committees before. Most go directly to the floor, but it doesn't make a constitutional ask. Right. So why?
No, thanks, Mr. Chairman. So my understanding is for an official designation, the mockingbird, the pecan tree,
okay.
For those, I believe those need to pass both houses in concurrent resolution form.
Okay.
But you're right, it would not need to amend the Constitution.
Okay.
Of course you're right.
Okay.
Of course you're right.
I just, because I've seen these in committee, so with that, let me ask this. Do you know the difference between a gun, a howitzer, and a cannon?
So I've heard good advice, Dean. Good advice, Dean. So we were using gun as a very broad term, but we want to make sure we're using it correctly. Right. And I should note, Texas does already have a state handgun.
Oh, okay.
And that's the 1847 Colt Walker.
Okay.
That's the state handgun, but this would use the broader term gun. I guess I was thinking guns of Navarone. Forgive me.
But a howitzer, a gun, and a cannon would all be a field piece.
Field piece.
So it is a crew-served weapon as opposed to a personal weapon. So I won't get into all the other differences, but that's the classic way for you to delineate between handgun and a gun, because you're talking about the field pieces like what we have on the Parrott gun or Napoleon III. We've got other cannons around the Capitol, but they are field pieces is what they are.
So one more time, and that's whether it's a personal versus
or crew-served.
Crew-served, thank you.
So,
Any other questions for the bill, Arthur? All right, public testimony is opened up on SCR 22. Chair calls Edwin Walker, waiting anxiously over there. Anyone else wishing to testify on, for, or against SCR 22, please get registered so you can follow up this panel. Go ahead, sir. State your name, who you're with, in 2 minutes, and position on the bill.
Yes, anxiously waiting. My name's Edwin Walker. For this bill, I'm testifying on behalf of myself. I come as a cannon enthusiast myself. I have several Winchester Model 98 signal cannons in my collection of vintage firearms. And so I understand and appreciate the role of the cannon. I've been enthralled with actually the folklore and the loss of the twin sisters ever since I read about a theory about where they could be, found in the book The Treasures of Galveston Bay, which was incidentally given to me by Sam Houston's great-granddaughter, Jean Houston Baldwin. But one of the reasons I wanted to speak was I know several years ago, and it was just mentioned, that the 1847 Colt Walker was designated as the official gun of Texas. I noticed from the State Archive site that it has now been listed as the official handgun. And so I just wanted to make sure that with the passage of this resolution that we don't undermine or in any way diminish the honor and recognition that had previously been given to the 1847 Colt Walker.
Thanks, sir. Any questions for this witness? I think you got off light. Thank you for being here.
Thank you.
I'm sorry. Don't get up and leave. Senator Zaffarini has a question.
Actually, I just want to point out, are you aware that we have very similar categories? For example, we have the plant versus the water lily. And so the plant is the bluebonnet, but the water lily has a particular kind of water lily. So we have many similar categories. This would not in any way diminish that symbol.
Yes, and it would be analogous to the large mammal being the longhorn and the small mammal being the armadillo.
And the insect being the mammoth butterfly.
So
we have 181 personalities in this building every 2 years, and they all come with something unique in their district. So,
well, one thing that I might recommend is that I know that the official dish of Texas is chili con carne. Might add, maybe we add the official fried dish, could be chicken fried steak. That's what I would have supported.
That's a
So
possibility.
just throwing that out there for somebody.
And I would
future
say the
residents.
irony of all of this is, in order to make something, or in our efforts to make something unique to a member's district, we actually make them very non-unique at the state level. Thank you for being here.
Thank you.
Yes, sir.
Thank you,
Thanks,
Mr.
sir.
Chairman.
All right. Anyone else wishing to testify on, for, or against SCR 22? Chair hears none. Public testimony. Oh, I'm sorry. Are you registered, ma'am? Okay, come on up and talk, and you'll get a card, and you'll need to fill it out before you leave. State your name, who you're with, and position on the bill, and 2 minutes.
I'm Fran Rhodes, again, with True Texas Project. And I'm sorry I didn't realize this bill was on this hearing notice for today. I obviously missed that when I reviewed the notice. But I love this bill. I'm here in support of this bill. Thank you, Senator Hughes, for filing it. And I just want everybody to know that at True Texas Project, we celebrate Texas independence every year with our big fundraiser gala called Texas Tough. And we have replicas of the Twin Sisters cannons that we fire off after the program every year, along with fireworks. And y'all are invited. Urge you to pass this bill. Thank you.
Any questions? You're dismissed. Thank you. Would you be sure and get you a card there before you sign out today? Thank you. With that, public testimony is closed. Which one? I will. All right, so Chair lays out Senate Bill 29 and asks Senator Senator Hughes to explain the bill.
Thank you, Thank you, Mr. Chairman, and thank you, members. Senate Bill 29 has to do with Texas as the destination for business. More business in Texas means more jobs, means more growth. And so we want to continue to attract companies here, in this case for legal domestication, for their incorporation here. So the bill does a couple of things. It codifies the business judgment rule. That's already the law in Texas, but it is a common law made by judges, and those things can change. So by codifying the business judgment rule, we'll give directors and shareholders confidence that courts aren't going to second guess their business decisions unless there's fraud, of course, or intentional misconduct. Also, public companies and large private companies can set a 3% ownership floor for derivative suits. That means frivolous claims could be blocked and letting leaders focus on growth and not litigation. Again, this would be allowed for corporations forming in Texas if they meet certain criteria. Also, we're going to send to the newly created Texas business courts the ability to confirm director independence early in the process. What does that mean? Let's say a company needs to do an interested transaction. Senator Perry, this stuff means more to you as a CPA than it does to most of us. An interested transaction between there's a shareholder and an employee of the firm and so of the company. And so that's got to be handled differently. And so under this law, they can go to the court, the business courts, and the shareholders get approval of this independent committee, and they can then take action without fear of being second-guessed, again, unless they do something fraudulent or something along those lines, intentional misconduct. Also, Senate Bill 29 would let firms set venue and lock internal disputes in those business courts, consistent with what Texas has been doing to give predictability and consistency so that as businesses consider leaving Delaware or incorporating somewhere else, we want them to continue to think of Texas. Also, emails and texts. Of course, a shareholder is entitled to inspect books and records of a corporation. This clarifies it's not talking about emails and text messages unless those communications drive corporate actions. And again, this is about common sense approach to give companies certainty. We want them to come to Texas. And I do have a committee substitute.
Chairman Hughes, send up committee substitute for Senate Bill 29. I ask the author to explain the differences between the sub and the original file.
Thank you, Mr. Chairman. I'll just go briefly through these. We amend the substitute, amend Section 6 of the bill. We were just talking about books and records and whether emails and texts are included in that. Section 6 clarifies that an email or other electronic communication does qualify as books and records if it effectuates a corporate act. If by that email or text we are taking this action, then of course of course, it's relevant, and subject to that disclosure. Amend sections 8 and 13 to give further details on that process to have directors certified as independent when we have an independent committee to review a transaction. These are non-substantive changes, but they make it more clear. Also, amend section 10 to clarify that the relationship between the business judgment rule and exculpatory provisions available under the existing Business Organizations Code are consistent. And again, it's a clarification of the language in the original bill. And then finally, we talked about putting a threshold in place for derivative suits. Now, we apply this to publicly traded companies, the thinking being that if the stock is traded, then folks always have a recourse. They can always sell their stock. In the originally filed bill, this was a drafting error on our part. The originally filed bill would apply to publicly traded companies and also to private companies, but this committee sub makes it clear we're talking about private companies with 500 shareholders or more. Of course, that's where SEC regulation is triggered at 500 shareholders, and those shareholders are going to be sophisticated investors, and so we do put them in a different category than like a family business or a corporation. Family business happens to be a corporation. That's what the committee substitute does, and we do have some very helpful witnesses who will elucidate these points and walk them through us, but of course I'll do my best to answer questions in the meantime. Senator Bardwell.
Thank you, Mr. Chairman. There are 3 places in the bill that, and maybe some others, but when I read through it, that used a term called derivative proceeding. What is a derivative proceeding?
Thank you, Senator. So derivative proceeding, sometimes these are called shareholder derivative suits. And again, the witnesses can help more on this, but if you're a stockholder in a company and you're concerned about how the company is being managed, about decisions that are being made, you as a stockholder, as an owner, can file a lawsuit, and it's called a shareholder derivative suit. It derives from your authority as a shareholder. This is not talking about
derivatives as an investment.
You bet. It's not talking about mortgage-backed securities or derivative instruments like that. That's a great point. This is about a lawsuit brought by a shareholder against the company. And I'll get the experts to help with that, but that's an important distinction, and thank you for asking about that.
Thank you.
Senator Hinojosa.
Thank you, Mr. Chairman. Just wanted some clarification as I'm trying to understand the language there. So this would offer those protections to directors in both publicly traded and private corporations?
Senator, yes, with this caveat. If this committee sees fit to pass the bill with the committee substitute, it would apply to private corporations only with 500 shareholders or more. Because when you get to 500 shareholders, you're subject to SEC regulation. So that is more like a public company. So for smaller companies, less than 500, if the committee substitute's adopted, it will not apply as far as the derivative suit limitation. That'll be for 500 shares or over.
Okay, thank you.
And thank you, Senators. These are, I know that members of this committee are well-versed in business and various subject matters. This is a very narrow in the sense of a area of the law we don't see very much. But if we think about the practical implications of this bill, we have the opportunity to really entice business to come to Texas. And again, that's more growth, that's more jobs, and that's the goal here. And again, the experts will be able to correct what I've said gently, I hope, and answer our questions. If there are no more questions at this time, then we'll open invited testimony. On Senate Bill 29, the chair calls Professor Shane Goodwin, Eric Lentell, Christopher Babcock. First, come on down, take any of those seats. And I'll just say to each of the witnesses, please don't just feel free, but accept my encouragement to correct or clean up anything I said. And you don't have to be nice. I know you will, but you don't have to. And just give us your testimony. We're going to have questions for you. This is really important. The subject matter can be a little bit dense. And so we want to make sure that the members of the committee and those who are watching and participating have a handle on what's being proposed here. So with that, welcome. Start over here. Introduce yourself and give us your testimony.
Well, actually, I think Mr. Babcock was going to lead off.
Very good. Counsel, get close to that microphone. Introduce yourself and go ahead.
Yes, sir. Good afternoon, and I'd like to start by thanking you and Lieutenant Governor for the leadership in introducing this legislation for the state of Texas. My name is Christopher Babcock, and I am the president of the Alliance for Corporate Excellence. I'm a practicing attorney in Dallas, and I focus on corporate law matters, including corporate governance in my practice. SB 29 introduces reforms to the Texas Business Organizations Code that I believe will make Texas a significantly more attractive jurisdiction for companies to establish as their legal home. You'll hear from other members of the business community the effect they expect this bill will have on drawing companies to Texas. A basic premise of corporate governance is that decision makers need to operate under rules that are predictable, stable, and knowable, so that they can deploy capital without fear that their decisions will be second-guessed after the fact in hindsight. Historically, Delaware corporate law provided these features, and many companies elected to incorporate in Delaware for that reason. Recent decisions in that state have challenged the assumption as to whether Delaware remains the right home for corporate decision-making. SB 29 makes Texas the right home for corporate decision-making by introducing a series of amendments to Texas law. And I'd like to mention in my prepared testimony 2 key amendments. First, as the chairman mentioned, SB 29 codifies the business judgment rule. The business judgment rule is the principle that a court should not substitute its own business judgment for that of a corporation's proper decision makers. And it's a cornerstone of corporate law. It serves to ensure that business decisions about deployment of capital, operations, and how to grow the enterprise are made by the corporation's shareholders and their duly elected directors, and not second-guessed by the courts. Codifying the business judgment rule and statutorily clarifying its scope gives guidance to allow boards to make decisions about how to run their businesses, confident that they can know and comply with the rule. Second, this bill empowers publicly traded corporations and large private corporations to establish an ownership threshold to be met before a shareholder or group of shareholders may bring a derivative claim. A derivative claim is one that belongs to the corporation itself, and the shareholder has the right to pursue that claim on the behalf of the corporation. And this provision, this threshold, helps ensure that these claims are brought for the benefit of the corporation's shareholders and not by mere nominal stakeholders without a true economic interest in the corporation. These and the other provisions of SB 29 will create the legal framework that corporate decision makers need to confidently operate their businesses. You'll hear from Mr. Goodwin and Mr. Lentel the effect that they anticipate these amendments will have on the business community and the opportunities the reforms proposed for the bill can create for our state. I'm happy to answer any questions, and I thank you for your time.
Thank you, and we'll hear from each witness, and we'll have questions for the whole panel. Thank you very much. Who's next?
Great.
Professor, go ahead.
Hi.
Dean.
Good afternoon, Chairman Hughes and esteemed members of the committee. First of all, I would like to thank you for bringing this along with Lieutenant Governor Patrick for the leadership to make Texas the unrivaled leader in business, economic development, and jobs. My name is Shane Goodwin, and I come to you today in support of Senate Bill 29. I bring more than 30 years of experience as a practitioner, investor, board member on both public and private companies, and a professor in corporate finance, mergers and acquisitions, investment banking, and I've worked at many firms such as Goldman Sachs, Citigroup, and Wells Fargo Securities over the years. I've also advised over 250 M&A transactions totaling $50 billion and executed over 100 public and private equity investments exceeding $40 billion. Beyond my experience in the banking and capital markets, I currently serve as the Associate Dean and a finance professor at Southern Methodist University's Cox School of Business and an adjunct professor at SMU's Cox School of Law. Both my work in academia and industry focus on corporate governance, mergers and acquisitions, shareholder activism, and financial regulation, issues at the core of Senate Bill 29. Through my decades and experience of advising companies, serving on boards, and conducting research, I have firsthand knowledge that legal certainty, business-friendly policies, and clear regulatory frameworks impact economic growth, job creation, and investment decisions. And that is why I support Senate Bill 29, which modernizes Texas's corporate law and positions our state as the premier destination for business and corporations and economic expansion. So why is Senate Bill 29 critical for Texas? For decades, as Mr. Babcock had mentioned, Delaware has dominated corporate and corporations. Nearly 70% of Fortune 500 companies have chosen Delaware as their legal home. However, Delaware's legal system has become increasingly uncertain and unpredictable, and the legal risk for corporations, their boards, and shareholders intensifies. And this uncertainty at this moment is already having a negative effect and somewhat of a chilling effect for companies while they're making these decisions that are headquartered here in Texas. As Mr. Babcock mentioned, Senate Bill 29 offers some very compelling features. I'll just highlight a couple. Codifying the business judgment rule ensures that directors and officers of Texas corporations can make business decisions without constant threat of after-the-fact second-guessing by activist judges. By protecting responsible risk-taking, this bill promotes innovation and job creation while maintaining accountability to shareholders. Ensuring derivative litigation is led by shareholders with a genuine stake in the business. This empowers corporations to set reasonable ownership thresholds for shareholders filing those suits. It provides legal certainty. This bill allows Texas-based corporations to designate Texas courts as an exclusive forum for internal governance disputes. This ensures that Texas companies can operate within a predictable legal framework. Passage of Senate Bill 29 represents an important step in solidifying Texas as the economic engine of the nation. With this legislation, Texas will become not only a hub for corporate headquarters and operations, but also a premier legal home for businesses seeking fair, predictable, and innovative, friendly business environment. I often highlight how Texas has led the nation in corporate relocations over the past decade, with 100 major companies relocating to this great state, choosing not to move just their headquarters, but their operations, employees, and long-term investments to our state. That decision is not made lightly. It is a strategic, high-cost endeavor driven by Texas' pro-business climate, skilled talent, and our low tax structure. If companies see Texas as a great place to build, grow, and employ their workforce, then why wouldn't they also ensure that their internal corporate governance affairs are governed and adjudicated here? It only makes sense that the same state they trust for economic opportunity should also provide a clear, predictable, and business-friendly legal environment, one that protects their ability to operate effectively and remain competitive. As someone who has spent decades advising businesses and serving on boards and researching corporate governance, I can say with confidence that Senate Bill 29 is a game changer. It will provide businesses with certainty, promote economic growth, and ensure that Texas remains the best state to do business. I look forward to discussing how this bill will drive the business investment, enhance Texas's corporate legal framework, and strengthen our economy for decades to come. Thank you.
Thank you, Dean. Welcome. Introduce yourself. Give us your testimony.
Good morning, esteemed members of the committee. My name is Eric Lintel, and I am General Counsel for Archer Aviation, one of the global leaders in developing the technologies and aircraft to power the future of advanced aviation in both commercial and defense sectors. Thank you for allowing me to be here today to testify on behalf of Senate Bill 29. I have worked as an in-house corporate lawyer at innovative companies for going on nearly 20 years. Before Archer, I worked at Google, and prior to that, Fitbit. Today, I'm here to talk to you about Archer and how these reforms could attract companies like ours to change their state of incorporation to Texas, and along with it, expand business operations and bring significant economic activity. Archer was founded in 2018, is headquartered in San Jose, California, and publicly traded on the New York Stock Exchange. I joined the company almost 4 years ago when the company was under 100 employees. We now have over 1,000, with the vast majority being based in our offices in the US. In November 22, we unveiled our first planned production aircraft, an all-electric vertical takeoff and landing aircraft, more commonly known as a flying electric taxi. At the end of last year, we launched Archer Defense, entering into a strategic partnership with Anduril Industries to jointly develop a next-generation hybrid electric propulsion aircraft for defense applications. We have also now opened and begun production at our high-volume aircraft manufacturing facility, which is a 300,000 square foot facility located in Covington, Georgia, just outside Atlanta. Archer is first and foremost working to commercialize our air taxi operations in and around major cities around the world. To do so, we have forged strategic partnerships with some of the leading airline operators in the world, including Southwest and United Airlines. With them, we are currently exploring the potential to bring our air taxis to both Dallas, Fort Worth, and Houston. When Archer was originally founded, it was incorporated in Delaware due to the state's history of having such an established and predictable corporate law framework. However, the landscape in Delaware has become increasingly challenged. At Archer, we have faced many of the challenges SB 29 is looking to address. That is why SB 29 presents a compelling case for us to change our state of incorporation to Texas. We have been in active discussions on this issue with our board and are looking to make a decision soon, as our annual shareholder meeting is coming up. There is no doubt that SB 29 would position Texas as a rival to Delaware by blending legal clarity with operational advantages. At Archer, we believe there is significant value in having our legal state of incorporation in a state where we are looking to have significant business operations. That is why we are strongly considering moving our state of incorporation and investing in building out our business operations and infrastructure in Texas. For example, we are currently considering whether to build out battery cell and composite manufacturing capabilities here, as well as bringing our early air taxi operations, which together could result in thousands of good-paying jobs right here in Texas. Thank you for your leadership and for considering how these reforms can help fuel companies like ours to continue to ensure the U.S. leads the way when it comes to innovation.
And thank you for your testimony. I'm going to ask a few questions of the panel, and of course, we'll yield to the members of the committee. Thank you each for being here. We use the term internal affairs sometimes, so help us understand the type of litigation that we're dealing with. So our understanding is this is litigation between shareholders and management. This is not about litigation between our company and another company, or our company and another business or an individual. If someone alleges that our company breached a contract, that's not affected by this, if it's dealing with an outside company. So far, so good?
Yes, sir.
And if there's an allegation that our company has harmed someone, run over someone, polluted someone, whatever the allegation might be, if we're dealing with persons outside the corporation, that litigation is not affected by this bill at all. Is that right?
You are correct, sir.
Okay. Help us understand what we are dealing with here when we talk about internal affairs.
Yes, sir. An internal entity claim is a claim that concerns the internal affairs of a corporation. That's defined in the statute essentially to be matters relating to the governance of the corporation, decisions by officers, directors, and others, and matters concerning the ownership or rights of the equity interest, the stock of the corporation.
Let me also ask about publicly traded corporations and private corporations. Most of our focus in our discussions has been on publicly traded corporations. So the shares are for sale at some stock exchange, hopefully more and more of those in Texas, but on some stock exchange, those shares are available. But of course, we talked about how in the committee substitute, we're going to clarify that for private corporations, we're talking about 500 shareholders or more. Help us with that distinction and how 500 shareholders or more differentiates those private companies from a mom and pop or a business back home we might be familiar with. Walk us through that, please.
Yes, sir. The intent of giving corporations the ability to set a derivative threshold is to make sure that when someone takes a claim that belongs to the corporation for the benefit of the shareholders, that person really represents the shareholders with an economic stake in the company. That's a problem you commonly see in public companies where outside groups with very little shares bring a case that the majority of the shareholders don't support. That's not a problem with a closely held family corporation. That's not a problem with a small company. And our goal, we view as empowering shareholders, not trying to take away the rights in these contexts where every shareholder has a close and intimate relationship to the company in a way that may not exist in a publicly traded corporation.
Thank you very much. I may have some more, but I'll yield to the members of the committee. Senator Safrani, did you have questions?
Yes, I do.
I'm proud to recognize the Dean of the Senate.
Thank you, Mr. Chairman. And this is to any one of you. How can we maintain our business-friendly reputation, so well-deserved, and yet at the same time ask relevant and pertinent questions related to the energy and water needs of businesses that want to move into Texas?
I'm sorry, could you repeat that question? I apologize.
Well, I asked it off the top of my head, so it may not be exactly
I bet she can do it.
I said, we're so proud of being known for our business-friendly environment in Texas, but how can we maintain that reputation and ask relevant, pertinent, appropriate questions to businesses moving into Texas about their energy and water demands on the state of Texas?
I think that's a great question, and nothing in this bill prevents us from asking those questions. This bill concerns internal decision-making by directors and shareholders and officers. It does not address the power of the state to regulate a corporation. It does not address the questions that can be asked. And so I don't know if I have a good answer for you as to how the state can ask these questions, but I can tell you this bill does not limit the state's power in that respect.
And I know that it does not, but my question is, how can we do that? In other words, we don't want to hurt our reputation. We want to be known as business-friendly, but we also want to ask those pertinent questions. And if you were before the Business and Commerce Committee, those questions would be asked.
No, I appreciate the question. I very much appreciate those. Those are questions that are beyond my expertise, and I don't want to pretend to be an expert on water use and energy questions. I think they're very good questions, and I think that our state has the power to ask these and appropriately manage our resources so that we can grow our economy while preserving what we have. But any particular policy there would be beyond my area of expertise.
Yes.
And Dean, I think, Professor, go ahead, then I think Senator Perry wants to respond to the question as well. Senator Perry, you go ahead, then we'll come back to you, Dean.
I was just going to say, as water has kind of been on in my picture the last few years, what we're finding is companies are beginning to ask questions about natural resources and power if they're having the conversation. And truthfully, it works well when both sides are very transparent and have those open dialogues so that there's not a unrealistic expectation that can't be met. Or usually what it is, we can do this, but it's going to take a little bit of time. And what I'm seeing and what's been encouraging is the companies looking to Texas understand where they're moving to, understand what's available. They know what they need. Texas knows what it can provide. And then they work out that balance on how to meet those needs responsibly. So it's happening, and it's surely just, it's kind of a part of the process. If they're looking at spending billions of dollars of infrastructure, they're having those questions on the front end now and asking those questions. And it's not a negative that Texas says, we're here today and we're moving forward tomorrow. And after we leave this session, I think those answers will be more clear. But there is an open dialogue. And I'll give you a good example, though. It's existing businesses seeing where our water supplies specifically are. There are existing businesses in the Corpus area that for numerous years have actually contributed on a front end to a fund to actually build out water supply. So we've got great corporate partners and we'll continue to have them. I think the key here is communication. So it's not a state doesn't get to tell them what we have and that they don't get to ask questions. It's a very open dialogue with that kind of money involved. But I've seen it firsthand in Corpus area. Those corporate partnerships of people down there needing more have stepped up, if you will, and the rates reflect a little bit of a buy-in to front load some of the cost of jump starting those infrastructures. So we're in a good spot, a great spot this session. We'll leave here hopefully with a plan that can address concerns coming in because they don't need everything today. They just need to know the state's going to work on it to have it solved for tomorrow. That's just been my experience in the water world.
Thank you. Did you have anything to add?
I did, Senator. What I do know is this bill doesn't preclude anything to obviously afford that, but what I can offer you is I currently serve on a board of a clean tech company. It is actually focused on water reclamation from produced water out in Midland. And that was actually a veteran-started business from our Tier 1 operators who actually just thought of the idea, and it generated out in California, but they actually decided to move here in Dallas, but in Texas, to actually produce this idea, and actually been very successful doing it. So I don't think there's anything that would preclude it. If anything, it would actually encourage it because of there's actually such great corporate governance around here to support their initiatives.
Thank you. I support this bill and intend to vote for it here and on the floor, in the Senate rather. But my very important question, because of feedback I have received, is what do you say to critics of this bill who say that it places business interests before the interests of workers, consumers, and communities?
What we would say is that this bill clarifies internal corporate decisions. It does not affect the rights of workers, of communities. It does not prevent corporations from, it does not take away anyone's rights. So we talk a lot about how internal entity claims are governed. Those aren't claims between a company and its workers. Those aren't claims between the company and its communities. And the rights of those other constituents are preserved and not hindered at all by this bill.
Well, then that's what I'll tell them. Thank you so much. Thank you, Mr. Chairman.
Thank you, Dean. Let me ask the panel a couple more things because I may have glossed over some important matters when I presented the bill. We talked about the business judgment rule, and I mentioned this is already the law in Texas. It's common law or judge-made law, and so this bill would codify it, place it in statute where all courts would be bound by it. And we talked about how it gives business some certainty, but talk a little bit more about what that means because we don't want to give business a blank check. Help us understand the business judgment rule and why it should be codified.
Absolutely. So the business judgment rule begins with a premise that corporate decision makers are experts at corporate decision making and courts are experts in matters of justice. To the extent something is a business decision, it should be left to the business decision makers, the board, I'll just say as a shorthand. It should be left to the board so long as rights and just actions are followed. And so the codified business judgment rule we propose makes it very clear. A claim for misconduct or fraud or malevolence, some affirmative bad act by a corporate director is still subject to judicial remedy. We're not trying to take, we don't try to take that away. What we do try to say is that you can take 100 years of Texas common law, you can put it in one statute where it's easy to find and review, and you can be protected against future changes in law. Sorry, you look like you had a... What we have seen happen in other states, for example, is you start with this same core, and it gets whittled away and it gets changed by sometimes cases where the initial case decision is a good one, but over time it expands to something that leads to significant second guessing of decisions. And what I mean by second guessing of decisions is not, well, were you looking out for yourself rather than the shareholders? That would be fraud, that would be intentional misconduct. What we're looking at is when a company's in court, it probably means something bad happened. And if something bad happened, it may have been something that a board could not have predicted, that a board looked at, made a risk allocation, and tried to decide. It is inappropriate to judge that decision in hindsight once risks have played out. And so by codifying, you create certainty, you ensure that future laws, future decisions don't whittle away uncertainty, and you preserve a judicial remedy where there are bad acts by corporate decision makers.
And so along those lines, that's very helpful. So would it be fair to say that we want to encourage the leadership of companies to innovate, to take risks, to increase the shareholder wealth, to benefit society? We want to encourage that. We don't want them to worry about getting second guessed because a decision they made ended up not being a wise decision. If they made a good decision based on the information they had, they should have a safe harbor. Is that too much to say? Is that a fair way to describe it?
That is a great way to describe it, sir. That is correct.
Thank you. Let me ask you all, Senator Birdwell, go ahead. Oh, good. Oh, thank you. Let me ask one more, then I'll yield back to the committee. Thank you, each of the members and the witnesses, for your indulgence. Let's talk about these independent committees. I gave a very cursory explanation. You gave a better explanation, but tell us a situation where an independent committee might need to be set up, why that would happen, and then what this bill would do. I think it's sort of in the same vein as the business judgment rule. Help us understand that. And again, it's a great point that Senator Zaffarini made. We are not talking about claims that workers make against a company or claims that the neighbors or the community makes. This is only about the relationship between the shareholders and the management. Is that right?
Yes, sir.
So tell us about these independent committees. What are they? Why do we need them? What would this bill do?
Yes, sir. So let's say, for example, that you have a company that is operating in any particular space, and there is a value accretive transaction. The company believes it can.
A value accretive transaction.
Sorry.
Everybody got that but me, but go ahead. Tell us what that means.
There is a transaction being explored that the company thinks will benefit the corporation and will benefit its shareholders. However, that transaction may be with, say, another director. A director may own a different company that the first company wants to acquire. Now, we don't want someone deciding something with, their hands in both, and we don't want someone deciding something who's on both sides of the issue. So a company might say, we think this transaction looks like it will be really good for us and for our shareholders, but we want to make sure that's not being tainted by a director who's got an interest in that transaction. And so we're going to form a special committee, an independent committee of directors who are independent, who we believe have only the best interests of the company in mind and who are disinterested from the transaction. Because our view is that it's best to let these disinterested persons look and evaluate and make sure they agree the transaction is the right one to do. That's why you might form an independent committee.
And so, let me change, that's very helpful. Let's talk about the law today. We don't know if this bill may not pass. I don't want to be arrogant and assume it will. It should, but let's say the law today, before this bill passes, how do you go about appointing that independent committee? What's the process?
Yes, sir. Before the law passes, the board would gather, they would identify the known conflict. The board would select directors who the board believed were independent. They'd do their diligence, they might ask some questions, they'd discuss what they know. The board would then appoint the independent committee and empower them to review and determine the transaction under the current law.
Go ahead.
Now, under the current law, what happens is the board has believed that these directors are independent. Nothing happens, nothing is publicly disclosed, nothing comes out. The transaction proceeds, and someone has a challenge with the transaction. Maybe it's someone in good faith, maybe it's someone in bad faith, but someone says, hey, I'm not happy that the corporation entered into this transaction, and they bring a lawsuit. At that time, because under our common law, courts respect the business decisions of the boards, the plaintiff would generally say, I believe that the members of this committee are not independent. And so the corporation has done significant work in exploring the transaction, in exploring the benefits to whether it's going to be successful or not. And all of this is done before the corporation has certainty that a court's going to believe that the directors that appointed as independent are independent. What that means is corporations often don't do transactions that they think would be good for the company because they're afraid they're not going to be able to prove that directors are sufficiently independent to be comfortable that that transaction will be upheld.
That's the current law today.
Yes, sir.
If Senate Bill 29 passes, what would change in how we appoint that, how we set up that committee, and how that affects the transaction?
What would change is the committee is still established, the board still does its diligence. The corporation then has the option to petition the business court, or if they're not in business court jurisdiction, another court, but they petition, presumably the business court, to say, we'd like to form this committee to evaluate transactions with with these persons. We want to give you all the facts that we can to the court. We'd like to appoint a neutral attorney and to let the corporation shareholders suggest alternative neutral attorneys to serve as a voice for the shareholders, not in that, for the non-directors, the independent shareholders. We're going to go to court and we're going to test to find out whether these directors really are as independent and disinterested as we say they are. And the corporation's going to be encouraged to give as much information as they can, because the result of this hearing is not a preclusive determination that can never be challenged. Rather, it's an establishment that, based on the facts the corporation said, these directors are independent. And so if the corporation was honest and upfront, it can be comfortable knowing that its independent directors will survive judicial scrutiny.
Chairman Hughes, if I can just add a note more as a board member.
Go ahead, Dean.
And somebody that has actually advised companies, primarily Delaware-related companies, I think this part of the bill is a game changer. I think it's extremely innovative. So it doesn't either chill doing a transaction or getting second-guessed by others after a transaction. So I do think this is an extremely innovative feature.
I'd like to add something as well. I mean, I think it's hugely valuable. For example, I'm dealing with one of these derivative claims right now in Delaware for a transaction that happened in 2021. We've spent tens of millions of dollars on litigation as a result of it. What we did is we created an independent committee. We were advised by an outside law firm that committee was independent. And so this would give us a step further to say, okay, we're not going to stop at that outside law firm. I'm going to go to the courts and have the court say whether or not they agree with that outside law firm's advice and allow us to go into that transaction, enter into the transaction with that certainty and not have to spend the next several years afterwards in litigation and millions of dollars of costs and sufficient amount of time.
Thank you for that. Senator Betancourt, you're recognized.
Thank you, Mr. Chairman. I think you mentioned that acoustics in the room are horrible. You said that no independent board member would survive a certain condition. You mentioned it just briefly.
Sorry, what I said is that the presumption is that the directors are independent based on the facts. But if there were facts that weren't disclosed, right, this doesn't allow a corporation to say, here's the rosiest story about these directors and then preclude a challenge. Instead, what the corporation says is, here are the facts we know. We believe these are all the relevant ones, and if those are all the relevant ones, then they've got a presumption that the directors are independent before they've gone down years and millions or billions of dollars in effecting a transaction.
Yeah, right.
Yeah.
Okay, thank you.
Thank you, Senator Betancourt. Senator Hinojosa, do you have questions? You're recognized.
Thank you, Mr. Chairman. And I apologize. I'm just trying to fully understand, and I think I have it right. I just want to just make sure. So your derivative claim threshold, you're saying that's for publicly traded companies and private entities with 500 directors or more, or greater, right? And that's to create that threshold. I think I understand that part of it. Is that
Yes, shareholders, not
shareholders? Excuse me, shareholders. Okay, that makes a little bit more sense.
That would be a big board.
Now, as far as codifying your business judgment rule, does that also have a threshold, or does that apply just for corporate law, even for small business? I know that's more rare for to have these kinds of incidences for small business, but.
So the business judgment rule applies to any corporation that's listed on exchange or corporations that opt in. That is, any small business that's comfortable with the current rules, that feels, hey, I know how Texas law works, may keep the current Texas common law. But any private corporation that says, I think these are likely to be an issue, has the ability to opt in to the codified business judgment rule.
And does it also apply for like limited liability companies?
So limited liability companies already have the contractual right to establish the duties of their board. This law does not change anything for limited liability companies.
Perfect. Thank you so much.
Thank you, Senator. Senator, is there any other questions for these witnesses? Thank you each for being here. Thank you for your continued work and consultation. This is a process, of course. There'll be there more languages being considered, and a lot of stakeholders are involved. Thank you each for your expertise, and we'll be consulting you again. Thank you for being here.
Thank you so much, Chairman. And thank you.
We'll open public testimony on Senate Bill 29. And the chair calls Glenn Hamer. There's Glenn. Is there anyone else wishing to testify on, for, or against Senate Bill 29? number of individuals and groups have registered their position not wishing to testify, and that'll be in the record, of course. Glenn, Mr. Hammer, welcome back.
Thank you,
Introduce
Mr. Chairman.
yourself. Give us your testimony.
Mr. Chairman Hughes, members of the committee, my name is Glenn Hammer, President and CEO of the Texas Association of Business. We're the state chamber for the state of Texas. In addition to all of our direct members, we represent about 250 chambers throughout the great state of Texas. And Mr. Chairman, I just want to start by thanking you and the Lieutenant Governor for your extraordinary leadership on this bill and so many other efforts that have made Texas the best place in the country for business. We would actually say now with our $2.6 trillion economy and growing, we have the best economy in the world. But now that SpaceX is headquartered here and incorporated here, why don't we just say we have the best economy in the galaxy? SB 29, Mr. Chairman, makes the state even more competitive. I'll just say the testimony from the three previous witnesses was just absolutely inspiring. The bottom line is Delaware has blown it. I mean, when you think about what's happened with California, you're going to see that same sort of migration of businesses incorporating and reincorporating in the state of Texas. It's a huge deal to codify the business judgment rule. It's a huge deal to work on the derivative suits, and this nice laminated cover of that Governor Abbott wrote last week in the Wall Street Journal really says it all about the importance of business courts in the state of Texas. Thank you, Mr. Chairman and members of the committee, for all that you do to make Texas the best place for business.
Glenn, thanks for your testimony. As long as I've known you, I can't believe I mispronounced your last name when I called you up here. I do it about half the time, but
it's close enough.
Glenn is easy, and so is Hammer. Members, any questions for the witness? So let me ask you one more thing.
Sure.
So obviously a lot of corporations, as we've heard, are not happy in Delaware, looking for someplace else to go. So my messaging expert says we should call this bill Dexit. What do you think? You like that?
I like it. I like it. I don't have a background in marketing, but this is such a big deal, and the message is out really to the entire country and the whole world that we're the best place for business. And when you think, this is a rhetorical question, if you have an internal issue as a business, are you going to be better treated in Delaware or the state that has become the economic engine of the United States of America? I mean, Mr. Chairman, if I could just say, I mean, for the 13th straight year, we won Site Selections Magazine's Governor's Cup that for the most economic development projects. We doubled up the second place finisher. It's like we win the economic development Super Bowl every year in the state of Texas by a score of about 50-10. And this just accelerates our lead. 20-plus year CEO Magazine's top state for business. So thank you. And this could be a nice economic, I would predict as companies incorporate and reincorporate here, this will also add to the record $23 billion surplus that the state of Texas holds. So, Mr. Chairman, I just want to, again, commend you, the Lieutenant Governor, for all of your work to keep Texas on top and to make us even more competitive in this area of incorporations and reincorporations. And I want to thank our friends at Texans for Lawsuit Reform as well, a great leader in this state.
Well, thanks, Glenn. Members, any questions for Mr. Hammer? Thanks for being here.
Thank you.
Is there anyone else wishing to testify on, for, or against Senate Bill 29? Seeing and hearing none, public testimony is closed. Senate Bill 29 is left pending at this time. We have motions in writing from Senator Betancourt and Senator Paxton. Without objection, those will be granted. What's next? How many witnesses?
Chair lays out Senate Bill 1033 and recognizes its author, Senator Hughes, to explain the bill.
Thank you, Dean. Senate Bill 1033 is a matter that was addressed last session by the Senate. Interesting fact pattern that has arisen and to be dealt with. Under current law, if a primary runoff candidate withdraws after the primary, but before the runoff, the remaining candidate is declared the winner and will advance the general election. This is true even if there's a third place candidate who could participate in the runoff. SB 1033 would resolve this by amending section 172.059 of the Election Code. This bill ensures that if a candidate who advanced from a primary election to the runoff then withdraws before the runoff is held, the candidate with the third highest votes would replace her on the runoff ballot. And of course, this gives a time frame in which they must withdraw. And members, if this is helpful, let's say there are 3 candidates running in a primary, Republican or Democrat, or what other party might have a primary in Texas. And so no candidate receives 50% of the vote. Let's say the first place candidate gets in the 40s. The second and third place candidates are each in the 20s. So second and third are pretty close. First place candidate got close to that 50%. So no one broke 50%. So there's a runoff between the first place candidate, who's in the 40s, and the number 2, who's in the 20s. The first place candidate then withdraws right after the primary, before the runoff. Conventional wisdom would be that 2 and 3 move up and have a runoff. But that's not the law in Texas. Number 2 is the winner. And so this bill says, in such a situation, if the first place candidate withdraws after the primary but timely before the runoff, the second and third place candidates would move up and then participate in the runoff. Obviously, the goal being that the candidate wins, which has the most support possible. Senate passed this last session, didn't make it all the way through the process, and that's what the bill does. I yield for your questions.
Are there questions of the author? There are none. Do we have invited testimony? There's no invited testimony. The floor is now open for public testimony. The chair calls Ed Johnson and Fran Rhodes. Mr. Johnson, please begin. You know the drill.
Ed Johnson. I'm here representing Harris County Ballot Security and myself. Just a little comment, maybe something to think about in this. You're moving the cutoff period from the 3rd day to the 5th day in the bill. When you're actually trying to run elections, especially runoff elections, it's a very short window to get all the work done for the logic and accuracy test to produce a ballot 45 days before the election to mail overseas. Maybe consider letting the logic and accuracy test proceed, because removing a name from a ballot is a really easy thing to do. Adding one creates all kind of problems because you got all of the ballot styles done, but removing one doesn't affect it much. But you could do the test, and then maybe after you do that, do just a test on that race that you removed or you added a name to. And that would allow election departments to proceed with producing the ballots in order to get them mailed overseas in time.
Thank you. Are there questions of the witness?
Madam Chair.
Senator Bettencourt.
Ed, what you're saying is that you would like to have a incremental test done just on the adding back of the logic test, of adding back the new candidate, and not have to re-logic test the entire ballot pattern, right?
Correct. Well, even the fact you have to announce you're having your test 3 days before it happens, so that would maybe fall within this 5-day window. And
so we should cut that to a day or something?
Cut it to a day and let you know.
Be happy to do an amendment whenever, but that's I think the point of cutting the logic and accuracy test back to one ad after it's been done is a good thing.
Yes.
Thank you. Ms. Rhodes?
Fran Rhodes, True Texas Project, representing myself and True Texas Project in favor of this bill. As I've said before, I'm always in search of common sense. This bill is common sense. Urge passage. Thank you.
Thank you so much. Are there questions of the witness? Thank you very much. Is there anyone else who would like to testify for, against, or on Senate Bill 1033 by Senator Hughes? If not, public testimony is closed and the bill will be left pending. Chair lays out Senate Bill 1362 and recognizes its author, Senator Hughes, to explain the bill.
Thank you, Dean. Senate Bill 1362 safeguards Texans' constitutional rights by banning the recognition or enforcement of red flag orders, also called extreme risk protective orders. It reinforces Texans' commitment to protecting the rights of law-abiding citizens while ensuring due process for all Texans. Here's the key points. There's a prohibition on local regulation. It stops all government entities or officials from adopting or enforcing rules, ordinances, orders, policies, or measures regarding red flag orders unless explicitly permitted by state law. It also ensures that any federal statute, order, rule, or regulation enforcing a red flag order that violates rights protected by the U.S. Constitution or the Texas Constitution is unenforceable and has no effect, null and void in Texas. Also, it bars the acceptance of federal money to implement, enforce, or administer federal red flag statutes, orders, rules, or regulations. It would be a state jail felony for anyone to enforce or attempt to enforce a red flag order against a person in Texas unless the order was issued under Texas law. And again, an emergency risk protective order is a court-issued order that primarily seeks to reduce firearm-related risk by either prohibiting a person from owning, possessing, or receiving a firearm or requiring them to surrender firearms. This applies only to orders that are not based on criminal charges. Members, and for those participating, this is a situation where a law-abiding Texan, based on a random report or complaint, can be deprived of their constitutional rights without due process. This bill is about making sure that doesn't happen in Texas. And of course, I'll yield for questions.
Are there questions of the author? Senator Birdwell.
Thank you, Madam Chair. Senator, on the page 2 of the bill talks about certain federal laws unenforceable. I know there was not a severability portion here because I clearly agree with what you're trying to accomplish. I don't know the status of federal red flag laws at this juncture. I don't know if there's anything that's federally required. So we may get into, with this section, we may get into a supremacy clause problem. So my recommendation would be to have some sort of severability of this should we not prevail in federal court, that the rest of the bill doesn't die because of this question related to supremacy not being severable.
Senator Birdwell, thank you for that. If you talk to the Legislative Council, their position is that under the Code Construction Act, every bill has a severability clause built in, but we've seen too many times where federal courts or state courts will enjoin an entire statute. So yes, we need to do that. Let's do that in a committee sub or on the floor if that's acceptable to you.
Well, I would defer to your judgment on how to do it. A federal judge is not going to be bound by what we put in state statute. And given what we've seen over the last 4 years, they may not even be bound what's in statute. Okay?
Sir.
So I don't want to see your bill fail for a supremacy clause purpose. But I'm not sure how to write that severability, so I would defer to your judgment because of your familiarity with the issue. So.
Well, we'll get some smart lawyers to help, and we'll work together if that's okay. Thank you for flagging that, Senator.
Thank you. Are there other questions? Are there invited witnesses? If not, the floor is now open for public witnesses. The chair calls Heather Kennedy, Fran Rhodes, Cristina Delgado, Bill Nance, and Sarah West. You have 2 minutes each. Enforced. Ms. Kennedy?
Good morning, Chair Hughes and members of the community and the committee. My name is Heather Kennedy. I'm a fifth-generation Texan and a volunteer with Moms Demand Action, which is part of the largest gun violence prevention organization in the country with nearly 10 million supporters who are fighting for public safety measures that respect the Second Amendment and help save lives. We strongly oppose Senate Bill 1362. Extensive research underscores the critical importance of extreme risk protection laws mitigating the risk of gun violence. These laws serve as a protective measure for preventing people in crisis from gaining access to a firearm. Extreme risk laws help de-escalate emergency situations. In many cases of gun violence, there are obvious warning signs that the shooter poses a significant threat long before a tragedy occurred. Extreme risk protection laws allow close family members and law enforcement to petition the court to temporarily restrict access to guns for people who are deemed to be at serious risk of harming themselves or others. Just last year, a woman suffering from a mental crisis attempted to commit a mass shooting at Lakewood Church in Houston. During a worship service, Denise Moreno opened fire, causing a tragic and senseless event. Despite her family's repeated efforts to raise awareness about her mental health struggles, including a battle with schizophrenia, she was still able to legally purchase a firearm. Research shows that in 32% of mass shootings with 4 or more people killed, the shooter exhibited dangerous warning signs before the shooting. Extreme risk protection laws also help prevent suicide. Researchers estimate that for every 10 gun removal cases initiated under Connecticut's extreme risk law, 1 suicide was prevented. This highlights the critical role that these laws play in saving lives. And in Texas, a staggering 57% of all gun-related deaths are the result of suicide. This bill would offer no benefit to the state of Texas, but it would disrupt the ability of law enforcement to effectively address dangerous individuals, making it harder for them to act in situations involving domestic violence or mental health crises. Moreover, SB 1362 would exacerbate the already alarming suicide rates in Texas as it limits critical tools that could prevent such tragedies. For these compelling reasons, I strongly urge you to oppose Senate Bill 1362.
Thank you very much.
Thank you.
Ms. Rhodes? Ms. Rhodes?
Well, I hope you all are not tired of seeing me yet, but this is my last one. I'm Fran Rhodes with True Texas Project, representing myself and True Texas Project. I am not a gun expert. In fact, I don't know anything about guns. I do, however, know something about the Constitution. The Second Amendment guarantees that government will not interfere with the rights of citizens to bear arms, and the Fourth Amendment protects people from unreasonable searches and seizures by government. Red flag laws violate both of those amendments. This legislation is important in protecting the rights of all Texans to possess firearms and the right to due process before any property can be taken away. Depriving people of clearly established constitutional guaranteed right in the absence of criminal charges is an affront to liberty and must not be tolerated. There is no real evidence that red flag laws work anyway. The New York Times has reported that the evidence for these orders is inconclusive on the effectiveness of them. The Washington Post has reported that California's red flag law went unused for 2 years after passage, and Washington, D.C.'s law has gone entirely unused. At the same time, other states have gone the opposite direction, seizing hundreds of firearms, and yet it's unclear if any of these actions have stopped any shootings. Further reason to shun these red flag laws is the broad possibility for abuse and fraudulent accusations. Any political opponent, angry neighbor, or paranoid family member can claim the need for such protective orders. Red flag laws would inevitably be weaponized against innocent citizens. We live in dangerous times, and we all agree that we would like our world to be safe, secure, and free from the threat of mass shootings. We mourn the nationwide loss of life from such tragic events. But haphazardly seizing guns from a citizen without some evidence or the due process of law is not an acceptable trade-off for potential future safety.
Thank you so much. Ms. Delgado?
Yes, hi, Senators. Thank you for having us here today. My name is Christina Delgado, and I am a resident of Santa Fe, Texas. I come before you today with my oldest daughter to formally express our opposition to Senate Bill 1362. Chairman Hughes and esteemed senators, as we deliberate upon this legislation and its potential consequences, I am compelled to consider the women and survivors whose lives and families would be negatively impacted. Extreme risk protection orders are specifically devised as a de-escalation mechanism to safeguard both community and family well-being. Having been raised in a gun-owning family, and as a member of a community that suffered a mass tragedy in 2018 at Santa Fe High School, wherein an individual accessed firearms belonging to his father and murdered 8 students and 2 teachers, the evidence presented before the Galveston County courts in 2024 unequivocally demonstrated that that young man was experiencing a severe mental health crisis. Had timely and appropriate intervention and support been provided to that family, a different outcome may have been achieved. Chris Stone and Kimberly Vaughn would have walked in their graduations, and Flo Rice would still be running marathons. Moreover, in Galveston County, my dear friend Melissa Knoll, whose protective order granted upon substantiated evidence of violence against her, had it been upheld and firearms been removed as mandated by her 2016 order, would be alive today celebrating her children's birthday. Furthermore, my friend, who has been grieving alongside her family and ours the loss of her son on May 18, 2018, might have succumbed to her distress during a moment of profound grief had her family not been able to secure and temporarily remove her firearms. We must make data-driven decisions based on evidence and facts, not fear and misinformation. Extreme risk protection orders are fundamentally about safeguarding lives and not disarming responsible, law-abiding gun owners like myself.
Thank you.
The narrative that oppose our mechanism for indiscriminate disarmament is a representation, misrepresentation.
Your time is up, ma'am, please. Mr. Nance, your time begins.
Good afternoon, Mr. Chairman, members of the committee. I'm Bill Nance. I'm the Military and Veterans Director for the Texas State Rifle Association. I'm here speaking on behalf of myself and the Texas State Rifle Association. Texas State Rifle Association fully supports this bill and recommends passage. Several states have passed laws regarding the implementation of extreme risk protection orders, commonly called red flag laws, with a myriad of different requirements. But the thing they all have in common is they deprive an individual of their right to keep and bear arms as provided for in the Second Amendment, as well as the protection against search and seizure of personal property guaranteed in the Fourth Amendment. Virtually all of these laws circumvent the individual's right to due process, sometimes on such flimsy evidence as a disgruntled ex-spouse claiming an individual has a firearm and has made a threat. Before the individual is made aware of that accusation, the firearms are seized, the home is searched, and the onus is now on them to prove to a court that that accusation was spurious. Even the ACLU has stated that, and I quote, "People who are not alleged to have actually committed a crime should not be subject to severe deprivations of their liberty in the absence of clear, compelling, and immediate show of need." The breadth and lenient standards in most ERPOs and granting of them are cause for great concern. A study conducted by the renowned statistician John Lott found red flag laws do not have a significant effect on murder, suicide, or aggravated assault rates. A DoD study showed that even if certain red flags are common among mass shooters, almost none of the people who display those signs are actually bent on violence. Who is to determine the difference between a loudmouthed oddball and a mass murderer?
Thank you, sir. Ms.
Thank you.
West?
Hi, my name is Sarah West. I am here representing myself, and I am against SB 1362. I cannot fathom the idea that we are discussing a law that could imprison individuals who attempt to comply with a potential federal extreme risk protection order law. You want to make it a crime for someone to follow a federal law that seeks to protect us from harm. This in itself is utterly preposterous. Texas is currently one of 29 states at the neutral threshold by doing absolutely nothing to prevent dangerous individuals from accessing deadly weapons? Do we really want to be worse than doing nothing? Do we want to punish those who seek to protect us from violent individuals? Do we want to allow angry and desperate people to roam Texas armed with the freedom to shoot anyone for any reason? I served on a grand jury in Travis County last year, and I have seen firsthand the level of violence in our community. Every Tuesday afternoon, I heard the same tragic stories of domestic violence. There has to be a better way to protect these victims. The majority of women I heard about said it wasn't the first time they had been threatened by their gun-wielding abusers. While I cannot discuss the details of these cases, I can speak with something you are all familiar with. In late October 2023, a student at Aikens High School in Austin reported that his tutor, Isaiah Smith, had committed an indecent act with a minor. An investigation began. And then in December, Mr. Smith was seen carrying a long gun and a pistol in front of Webb Middle School and St. Francis School in Austin, terrifying children, parents, staff, and neighbors. Senator Betancourt, you were quoted by saying that...
Are there questions of the panel?
Excuse
me? If not, thank you very much. Your time is up, ma'am. We're trying to finish by 1:45, so we're strictly enforcing the rules. The chair calls Kyle Rittenhouse, Chris McNutt, Nicole Golden, Ian Molidina, and C.J. Grisham. Thank you, panel. Please begin.
Chairman and members of the committee, my name is Kyle Rittenhouse, and I'm here today representing myself and the members and supporters of Texas gun rights to speak in support of SB 1362, a bill that defends the rights of law-abiding Texans from dangerous and unconstitutional red flag gun confiscation laws. I know firsthand the importance of self-defense and the weight that comes with exercising that right. But I also know how quickly false accusations and misinformation can be weaponized to destroy a person's life. That's exactly what red flag laws do. They allow firearms to be seized without a crime being committed, without a conviction, and without giving the accused a chance to defend themselves in court. These laws violate due process and strip people of their rights based on accusations that may be false, exaggerated, or rooted in personal or political disputes. Imagine losing your ability to protect your family, your home, and your life, all because someone made an accusation without evidence. That's not justice, that's government overreach. SB 1362 is about protecting the rights of Texans and ensuring that no one is punished without due process of the law. I urge you to support SB 1362 and stand with Texans who value freedom, justice, and the fundamental right of self-defense. Thank you for your time.
Thank you so much. Mr. McNutt?
Yes, Chairman and members of the committee, my name is Chris McNutt, and I am the president of Texas Gun Rights. And to be good stewards of y'all's time, I know you're on a short schedule, and to not repeat everything else that's been said here today, I just want to thank Senator Hughes for filing this critical bill. It is the #1 legislative priority for the members and supporters of Texas gun rights. And I strongly urge all of the members of the committee to sign on to the bill with the senator and also vote for passage. Thank you very much.
Thank you very much. Ms. Golden?
Good afternoon, Chairman Hughes, Vice Chair Paxton. I see she's not here, and committee members. My name is Nicole Golden. I'm the Executive Director of Texas Gun Sense. We respectfully oppose SB 1362 and wish to demonstrate that ERPOs are effective, safe, and legal. ERPOs do balance robust due process procedural safeguards with timely intervention to prevent harm. By authorizing the temporary removal of firearms and prohibiting an individual from purchasing or possessing firearms while the order's in effect, ERPOs provide a critical opportunity to prevent mass shootings, homicides, and suicides. This bill itself defines ERPOs as having the primary purpose of reducing death or injury related to firearms. With more than 4,000 Texas gun deaths a year, this is something we should be doing more of, not less. There's evidence that ERPOs have averted tragedies. In Florida, which has issued the largest number of risk protection orders since passing the measure after the Parkland shooting, there was a case involving a 30-year-old highly intoxicated subject in crisis who armed himself with an AR-15 and chased a group of students. The subject was served an ERPO and a year later had turned his life around, the ERPO expired, and he had no further contact with law enforcement. ERPOs from other states are specifically drafted with preservation of due process and have not been found unconstitutional on those grounds. Michigan, for example, establishes criminal penalties for petitioners who knowingly and intentionally make a false statement to the court, and no one's been charged with this offense. And as far as I'm aware, the courts have not found that ERPOs violate the right to bear arms or the right to free speech. Furthermore, the Supreme Court said last summer that it does not violate the Second Amendment to deprive someone of firearms if they pose a credible threat. We're concerned that this bill would prohibit enforcing out-of-state ERPOs. Imagine if a state prohibited the enforcement of out-of-state domestic violence protective orders. This regards the full faith and credit clause, which requires states to respect the laws and judgment of other states, and results could be devastating for people. In conclusion, I really want you to know that support for ERPOs in Texas is high. 88% of Texans, including 81% of Republicans, support it.